Justices of the Appellate Division, Fourth Department, hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and it shall be heard.
Thank you. Please be seated. First case on the calendar for argument today is People versus Phillips, number 339. We could also call, if counsel does not object, we call 344 at the same time. The two cases, the briefs seem almost identical.
Yeah.
And it was a joint trial.
Yeah.
So you can argue both at the same time if you wish.
Thank you.
Thank you.
Morning, Your Honors. Derek Andrews with Larkin and Gracia on behalf of Andrea Phillips and Clifton Phillips Jr., the defendants and appellants in this case. May it please the court. Although we raised several distinct points in the underlying appellate briefs, there are three key mistakes that I think bear the attention of this court that I truly believe caused the result in this case, that being the convictions and sentences. Those three errors happened at three different but crucial stages in the proceedings and coalesced in, frankly, what I would call a mess and contributed to the convictions and sentences. So those three primary errors or mistakes included the people's failure to provide complete discovery as required by Criminal Procedure Law Section 245, which totally deprived the defendants of a clear and complete picture of what transpired, particularly law enforcement's entry into their home and the circumstances that allowed them to do so. And I would actually include the Brady violation that we argued in point 3 here as well. The second error was the collective failures of defense counsel to ensure that they actually had and possessed and reviewed full discovery from the district attorney's office. There were flashing lights or breadcrumbs all throughout the discovery as it was sent to defense counsel that would have allowed them the opportunity, had they adequately reviewed it, to figure out what was missing. And then the subsequent failures of defense counsel to make non-boilerplate, factually based suppression motions, especially given that the evidence obtained as a direct result of the search warrants was the very same evidence used against the defendants at trial. And finally, at trial, the court's Molyneux ruling and the violations of it by the people and their witness were the final nail in the coffin, if you will, the final error that requires relief of this court because the lower court allowed the jury to consider items recovered from the earlier July 22nd, 2019 search that plainly amounted to criminal propensity and nothing more. But why should we care? As to the first point, missing discovery, we should care because New York substantially changed its discovery paradigm with the advent of CPL 245. And in doing so, they removed the blindfold.
Counsel, I think as you recognize in your reply brief, 245 took effect after this case commenced. This case was commenced before the statute took effect, correct?
That is correct, Your Honor. 245 took effect January 1st, 2020.
Right.
The reforms having been hotly debated, as this court pointed out in People versus King, the Fourth Department decision. And as was pointed out by Judge Rivera in her dissent to the Court of Appeals decision on People versus King. And so while CPL 245 might have taken effect while this matter was pending, what this court said in its Fourth Department decision, what Judge Rivera had noted in her dissent with respect to People versus King in the Court of Appeals, was that because it was procedural, it would allow it to take effect in matters still pending.
I was on King here and I did like what we said, but the Court of Appeals didn't.
So did I.
We got reversed on that one. But it's an open question of whether 245-20 sub 1 applies. But that's still an open question. What's not an open question is whether it's tied to speedy trial anymore. So so the best you can get, would you agree here, is a discovery sanction, not dismissal for speedy trial?
That is correct, Your Honor. We would concede, unfortunately, that the Court of Appeals closed the door on a speedy trial issue in the limited set of cases where 245 and 3030 took effect as they were pending.
Right. So you're looking for a sanction. It could be dismissal, I guess, under 245-80. That's one of the possibilities, but we're just talking about a sanction here. And for some of this evidence that you feel should have been turned over sooner.
That is correct. And we pointed out in the underlying appellate brief all of the items that were missing. The audio and video recordings of the July 1st and July 12th, 2019 controlled buys, which law enforcement averred in their affidavits that they preserved, that they existed, those were never disclosed. CPL 245-21G would have required all tapes and electronic recordings. CPL 245-21E would have required all statements of involved parties, written, oral, or recorded.
Well, you contend Daryl Mosley was a witness that we needed, the people needed to turn over any statements and evidence regarding him. What the people say is your client wasn't charged with any of those controlled buys from Mr. Mosley. And that's, as you know, the first search, those charges were dismissed. So Mosley has nothing to do with this case. That's their position.
And I would disagree with that position because CPL 245-20 sub 1 specifically states that all material related to the subject matter of the case needs to be provided. Daniel Mosley's involvement, because it was part and parcel to how law enforcement applied and obtained the search warrants based on the July 1st and July 12th, 2019 controlled buys, absolutely needed to be disclosed. And beyond that, People versus Giesland, Court of Appeals, says that all information bearing on a suppression motion and a decision by a trial court has to be provided. And that's well in advance of 245.
What with respect to Mr. Mosley wasn't turned over? In your view, that should have been turned over.
Your Honor, at the very least, his contact information. Obviously, the confidential informant who allegedly had connection to Mr. Mosley would have had a means of contacting him. So Daniel Mosley's contact information needed to be provided. Daniel Mosley's criminal history needed to be provided as someone who was related to this case, and criminal history for all witnesses needs to be provided, irrespective of whether or not the government actually intends to use or call that person as a witness.
You may proceed to your other points if you wish.
Thank you, Judge. With respect to the trial stage, the lower court's Molyneux ruling and the people's violations of that, not only in their opening statement, but allowing their witness to talk about specifically what was recovered and that it was crack cocaine, again, in direct violation of the court's Molyneux ruling, allowed the jury to consider items recovered from the earlier July 22nd, 2019 search that plainly amounted to criminal propensity and nothing more.
Do you agree that the mail and the cash were admissible from the July 22nd search as fruits relevant to the second trial?
I'm not so sure that the cash was admissible, but certainly the mail is. I did concede in the brief and in the reply brief that certainly identity and residence at the home would have been permissible given that the government's case relied on constructive possession. But beyond that, I don't think that
it's the cocaine and the cash that you're more concerned with.
The cocaine, the cash, the scale recovered on July 22nd, the little bags that were found in Clifton's bedroom, as well as the marijuana.
Are those items found in the headboard?
So the marijuana bags, and I believe marijuana in the bags were found at the headboard. The cash was found in Andrea Phillips' bedroom.
Didn't the jury ask for what was found in the headboard?
They did, which resulted in an entire readback of that particular officer's testimony. So what was the first part of that entire officer's testimony was about everything that happened on July 22nd, 2019. So it included everything that was found on that date, which included things that I think would have been permissible, again, the mail and presence at the home. But it also included Officer Norris's allegation that they found crack cocaine, marijuana, the bags, as well as the scale.
Didn't the court indicate that that testimony was would complete the narrative for the purpose of the second search warrant?
Your Honor, I have to admit, I have always struggled with the people's belief that they need something to complete the narrative, and particularly in this case.
Every case you have a problem?
Not every case. I just mean that it is it's a farce, in my opinion, because at least in a drug possession case, all they needed was what was recovered on July 24th, 2019, because that's the only offenses that were charged in the indictment. If we are to accept the government's proof, certainly possessing well over 200 grams of heroin and fentanyl with a cutting agent and a scale is sufficient on its face for not only possession of heroin and fentanyl greater than 8 ounces, but certainly sufficient for possession with intent to sell. Everything on the July 22nd, 2019 search was simply unrelated to that conduct. It's not the same drug. Both the marijuana and crack cocaine are different than heroin and fentanyl. It's on different dates. They're in different locations. There's no connection between the bags found in the Clifton Jr.'s headboard or his bedroom versus what was found in the unoccupied third floor attic. There's, as I've reviewed in our state's jurisprudence on Molyneux issues, there has to be commonality between the uncharged conduct or prior bad acts and the currently charged conduct. And that simply didn't exist here.
I think what it comes down to, and we're going to take a close look at it, is whether it was relevant to possession, because they were not in the house. Your two clients were not in the house at the time the second search warrant was executed. The people's theory was that the fact that they were there sleeping early in the morning on the first search and their mail was there, that shows that they had some connection to the premises. So that's their theory on that. And they also say the cash is relevant to intent to sell. So, but I agree with you. The court's ruling on the cocaine, it was never tested to be cocaine.
Correct.
It was never determined for whatever reason. It wasn't submitted, and that's why the first indictment was dropped. The court did say that there should be no reference to the fact whatsoever that the cocaine that was there was cocaine. And then we had a police officer get up there and testify exactly to that it was crack cocaine. So I understand your point there. We're going to take a look at it in the totality to see if there's a reversible error. You have a few others I believe you want to get to?
Yes, Your Honor. With respect to just to add on a little bit to the Molyneux issue, is the fact that the people in their opening statement went right out and said that the testimony is going to show evidence of drug sales and that Andrea Phillips was a target of this particular investigation. That, I think, by itself was a violation of the Molyneux ruling, and it just sought to cloud the jury's judgment as to whether or not the defendants were actually guilty of the charged conduct on July 24th, 2019.
Was that preserved?
It was preserved with right after the people's opening statement, both defense counsel objected and sought a mistrial. And I did want to point out along the same lines of Molyneux, Your Honors, is the people's reliance on People versus Echeverria, which appears to offer a great soundbite for them. The problem with that case is that it is light on reasoning regarding that soundbite. And that soundbite was something to the effect of the court permitted Molyneux testimony about unrelated prior drug sales. But absent from that opinion is any sort of explanation about why that was the case. So I don't think that that case is truly supportive of the government's application for Molyneux, especially because that court, the lower court, which the third department pointed out in Echeverria, did say that it precluded Molyneux testimony regarding drug sales made by the defendant to the confidential informant in that case that happened just a day prior. So there was Molyneux protection for the defendant in that case. But the people's soundbite regarding unrelated prior drug sales being admissible for Molyneux purposes, I find that to be without support in that opinion, and I don't think it offers enough for relevance in this particular case. And with respect to our arguments that the defendants received ineffective assistance of counsel, Your Honors, as I pointed out, the failure was not solely making or not making at all factually based non-boilerplate suppression motions. It was the failure to ensure that they were actually equipped with full discovery in order to be able to investigate the claims that their clients had made that they were innocent and wronged by law enforcement, the claims that the July 1st and July 12th, 2019 controlled buys never actually happened, that Daniel Mosley wasn't ever actually involved. And without those facts, the suppression motions that Andrea Phillips' attorney did make were denied out of hand. And that is, for all intents and purposes, in violation of the Court of Appeals precedent in People versus Claremont and the Fourth Department's very recent authority in People versus Conley, in that if we fail to make a good suppression motion, where that suppression motion is covering the very same evidence that is going to be used against someone at trial, then that is ineffective assistance of counsel, even if it's just that one failure. But there are
your client's theory, just to sum up, because you are running short on time, is that the CI was lying, Mr. Mosley was lying. The police, when they went into the house both times, planted drugs, and there should have been some pretrial mechanism by which defense counsel challenged the veracity of all of those witnesses. A Frank's hearing, some type of other challenge to show that your client's position is that everyone was lying. It was a vast conspiracy of everybody against them, and there should have been some motion to that effect.
Yes, Your Honor. Unfortunately, there is a substantial amount that either did or did not happen on the record, which prevents us from being able to fully explore this here on direct appeal. But a 440 motion had been filed and was regrettably denied on those very points. So yes, that is the defendant's position.
We appreciate your argument. Thank you very much.
Thank you, Judge.
Morning, Your Honor. Brad Osler for the People. Start with the discovery aspect or the 245 aspect. It would be my position that 245 just flatly does not apply. And I say that because if we were to read the Court of Appeals opinion in King as sort of parsing out 245-50 and its connection to 30-30 and saying that doesn't apply, but 245-80 or other aspects of 245-20 do apply, then I think we're unnecessarily parsing a statute which was enacted all at once. So I mean, a whole article of the CPL. So I think it's, in my view, it's quite plain that 245, no aspect of 245 can apply here. 240-20 or Article 240 certainly did apply at the point in time when this case was, for the most part, being litigated, or at least partly being litigated. 240-21G, which would govern the controlled buys, indicates that those have to be disclosed if they're intended to be used at trial. And obviously there was no intention, there was no use of those recordings at trial. So I would say that the controlled buys fall outside of
were there actual recordings made?
Based on what we have in the record, it appears there were audio recordings.
But not of that phone call that Mr. Mosley said he overheard about from one defendant saying, thank goodness the police didn't find the other drugs in my.
That is
secret
my
bag."
understanding,
Okay.
yes.
What about this, this Molyneux issue, the people's application? They said, we want to use from the July 22nd search that resulted in an indictment that was dismissed. From the July 22nd search, people wanted to use the money and the mail only. That was the people's application from Mr. Lynch right before trial. The court granted that application and then says, as I indicated previously, instructed the prosecutor should be no mention that this white substance that was never tested was cocaine. That's your understanding of the people's application and the court's ruling?
Yes, it is.
And then we get to trial and the police officer testifies that he found crack cocaine there during the July 22nd search. So you would agree that testimony, maybe unanticipated by the prosecutor, but that testimony exceeded the scope of permissible Molyneux evidence?
Yes, absolutely. I would readily concede that.
So where does that leave us? Is it a harmless error situation?
I mean, I think it has to, at least with respect to that mention. The court, offered a limiting instruction right afterwards to direct the jury that the officer's opinion was to be disregarded or something along those lines. I think, though, when we turn to the harmless error analysis of it, I think what we're left with is the results of we have to kind of focus on the results of the second search, of the July 24th search, because the evidence there, I mean, is significant. That's not it's not a, we might be in a different position if the charges here were CPCS 7th or something like that. I mean, these were very, very high level charges, and we're talking about a tremendous quantity of drugs. And when put in conjunction with the, what I would say is obvious indications of sales, you have the envelopes, rubber bands, stamps, scales, calibration weights. You have $4,000 of small denomination bills, many of which are crumpled and stored in a place which I think we might all agree is not normal.
But Counselor, given all that, why do you need all the evidence of the prior?
Well, that speaks to possession. And as I think was brought up a moment ago, the defendants were not in the house on the morning of the July 24th search. So possession's an element. We have to establish that. We have to establish the constructive possession.
Right.
All of that, the mail, the other evidence of sales, the fact that they were living in the house at that point in time, certainly. I mean, we know they were there on the morning of the 22nd. All of that clearly speaks to the constructive possession, to the idea that there's no reasonable doubt here that they could have sort of accidentally been or incidentally been overnighting in a house where this was occurring and not had
But I think Justice Greenwood's question is, how does the cocaine evidence relate to possession? I get the mail.
The violation of the Molyneux order I would not argue that should have been brought up. Certainly I think the court's ruling on that was reasonable. The charge was dismissed. We did not have a test to confirm what it was. So certainly, again, I would not disagree that shouldn't have been mentioned. But in light of the bulk of, the rest of the evidence, I don't think that could be seen to have.
It would seem like your argument really with harmless error is the most incriminating information is that there was a warrant executed there anyways. The jury heard that. They heard that they were staking out the house and watching for days and days. That it's not going to come as a huge surprise to anyone listening to that information that the police might have found some drugs in there. But we're going to have to look at that because there was a Molyneux violation.
Mm-hmm.
On the discovery, on this fingerprints, there's a lot of talk about the fingerprints that came up that the police were not able to discover or obtain any latent prints that were usable. Is that Brady? Counsel says that's Brady. That's separate and apart from discovery.
Sure. And
is that Brady information?
I've laid out in my brief a few different ways in which I think it is not. If it was someone else's prints, if it was, I don't know, some other piece of evidence that might actually suggest innocence or lack of guilt, we certainly have a problem there. But based on the standards that we have, it's not only is it not exculpatory on its face, but I would say it's not material, and certainly there was no prejudice.
Why is it admitted then to evidence by the people?
Well, it was disclosed because it was requested and we did have it. I mean, I think that was an oversight, but it was used on cross-examination, certainly repeatedly by the defense to emphasize the obvious point here. Well,
Right.
how can you connect the defendants if the fingerprints are on it? I understand that, certainly. That's an obvious, reasonable strategy. But we have, the structure we have by which we analyzed Brady would not wholly classify this right into that category. And I point in the brief to the Murray case from this court from, I forget the exact year, I think it was the late 90s. It's essentially identical.
It's not exculpatory, it's not inculpatory, it's neutral. And that's
Correct.
neutral is in Brady in your view.
Correct.
Do you wish to be heard on any of the other issues?
No, I think our the ineffective assistance I've addressed in the brief. So if there's no other questions, I'll press. Thank you.
Next case for argument is 342 People versus Jose Lopez Nunez.
Morning, Your Honors. May it please the court, Guy Talia on the Monroe County Public Defender's Office on behalf of Appellant Jose Lopez Nunez. As an initial matter, I'd like to note that the people conceded that the waiver of appeal here was invalid. So to the extent any of the arguments would have been precluded by a valid waiver of appeal, that's not an issue in this case. Turning to our second argument, based upon Erlinger versus the United States, and the invalidity of the predicate finding because Mr. Lopez Nunez was denied a jury determination on the tolling issue. We acknowledge as the people have submitted the recent Court of Appeals decision in People versus Mitchell Hernandez. In Hernandez involved an Erlinger argument similar to the one made here. There, like here, it was not preserved. There, like here, the defendant did not dispute the dates of incarceration. Contrary to the people's contention, the Court of Appeals did not hold that preservation is required for an Erlinger argument. It held as a threshold matter that because the dates were not disputed, it did not need to reach the issue of preservation and consequently the merits of the Erlinger argument.
And I think they made it pretty clear during oral argument, Hernandez, that their jurisdiction is different than ours. We can reach it in the interest of justice if
Absolutely.
we wish to, but you're not
Yes.
disputing, this is not preserved for our review. Question is, do we get into it? I think there was a First Department case just released last week. I don't know if you saw that one.
I would agree, Your Honor, that under the authority of Hernandez, that this court need not reach the issue of preservation or the merits of the Erlinger argument. However, as you noted, it can reach the merits of the Erlinger argument as a matter of discretion in the interest of justice, and we urge it to do so. We urge this court to do so for a few reasons. First, the failure to dispute should not preclude review of this issue. We made an argument here, and I don't believe it was made before the Court of Appeals in Hernandez, directly addressing that issue. And the reason why that should not preclude review is because the failure to dispute does not and cannot amount to a resolution of that factual issue in favor of the people any more than the failure to dispute the allegations of an indictment amounts to an admission or resolution of those facts in favor of the people. I discussed this argument in detail in our briefs. I'm happy to explain it more here if the court wishes.
But Counsel, how about getting to the issue of what makes this in the interest of justice? He was on parole. He's he admitted the as you said, he didn't dispute. Go there. You want us to look at the interest of justice. So that's here. Specifically that involves this individual. He was on parole, he had the weapon, semi-automatic.
Sure. So there's important justice issues in this case, both on the facts of the case and on a broader level in terms of the operation of the courts and administration of justice. To address your question directly with respect to the facts of this case, Mr. Lopez Nunez is serving a sentence of 12 years to life. His prior convictions were criminal possession of a weapon convictions, passive possession. Gun was never drawn in those convictions. shots were never fired. No one was ever injured.
He didn't contest his criminal history, right?
He did not contest the fact of those prior convictions, no.
Did he contest the periods of incarceration for tolling?
He did not contest that either, no.
So if we were to reach this thing for justice, I mean, and your point is that the jury should make these determinations, but is there any indication that he has any shot whatsoever of winning factually, given his record and his periods of incarceration?
Well, I mean, we really don't know. I mean, we don't know what he would have done if he would have disputed them, if he thought it would have went to a jury
Well, we
or,
know his dates of conviction, right? And we know what convictions are, we know what his sentences were. Or can't we just do the math and figure out if the 10-year tolling period applies? Again, that's, your point is that we shouldn't be doing that, it should be the jury, but again,
sure.
you're asking us to, in the interest of justice, send it all the way back there and have a jury, if a jury is required. And the result is gonna be the same. Unless you can point out something different with his dates of conviction and how much time he served.
Well, I mean, I don't have anything in the record as to contest the dates for the reasons explained before. I mean, whether the outcome may or may not be different, I guess depends on if it goes back. Well, actually, if you review this in the interest of justice under Erlinger, it wouldn't go back for a resentencing. We're asking you to find that he should be sentenced as a first offender because there's no jury opportunity for a jury under the statute. So the interest of justice review would be to sentence him as a first offender, which we think is in the interest of justice here because in 29 states, permitless carry is not even illegal. So what he did is not even a
charged as a
crime.
predicate here, he'd be, or sentenced as a predicate, he'd be sentenced as so he's sentenced here as a persistent. So not as a predicate, this is the first time.
Right, that's what we would be asking for in the interest of justice review if you review the merits of the Erlinger argument, the result would not be going back to resentencing.
I understand, that's a legitimate point.
Right. And we do think that is important in the interest of justice. Whatever punishment you think he may be entitled to receive for passive possession of a weapon, that was the instant charge as well. It's not 12 years to life. It should not be 12 years to life. Like I said, in 29 states, permitless carry is not even a crime. So in 29 states, what he did wouldn't even be considered a crime, and here he's serving 12 years to life. So moving on to our third argument, which does kind of go to the questions you were asking earlier. Even if this court doesn't reverse in the interest of justice under Erlinger, the matter should be remitted for resentencing because the predicate statement here did not include both the dates of incarceration and the places of imprisonment, which is required by the CPL. Contrary to the people's contention, a statement without places of imprisonment does not constitute substantial compliance. This court has held that, the First Department has held it, and Third Department have all held that without both the dates of incarceration and the places of imprisonment, the predicate statement is non-compliance with the statute. And has each of those courts, even if the issue didn't appear to be reserved, has remitted it for resentencing for people who get to submit
On an
a new
interest of
predicate statement.
justice basis.
No, that would not be, that argument is not based upon the interest of justice. That argument is based specifically on the failure of the predicate statement to comply with the CPL because it didn't include the places of imprisonment.
So you're saying that it doesn't have to be preserved for that issue?
Well, I don't think it needs to be preserved. The cases didn't discuss why they were sending it back in the Fourth Department, in this court, in the First Department. The Third Department remitted it in the interest of justice. Yes, they did if it was unpreserved. But I think it would have fallen within the illegal sentence exception as well. And also the exception because there was simply no factual record that could have been developed or that wasn't developed by the failure to raise it below. So nothing else could have been done below if that was raised. So we're just asking to do what the trial court would have done if it had been raised and have the people represent a proper predicate statement for resentencing.
Thank you, Mr. Todd.
Yeah, thank you, Your Honor.
Morning, Amy Wallenbach on behalf of the people. The Court of Appeals decided the preservation issue with respect to defendant's Erlinger claim. And this is an identical situation. The defendant in Hernandez admitted to the predicate status at sentencing. Same thing here. I'd also like to put a finer point on our argument here. It's not just that defendant didn't contest his predicate status. Here, he had to admit to being the same person that committed the prior felonies as part of the plea agreement and sentencing. So this wasn't some sort of just, passive non-acknowledgement.
He got
He
an
admitted to
affirmative
it.
benefit in response, in
Yeah.
return for that acknowledgement.
Yes, he got the minimum sentence that was allowed under law for a persistent violent felony
And the
offense.
charge was reduced as well pursuant to the.
I believe so. I believe it was originally charged as criminal possession, or criminal possession of a weapon second, and then it was reduced to an attempted.
With the
So-
understanding that he admits his status as a persistent violent felony offender and so forth.
Yes,
This Erlinger claim, has that no appellate court has passed on whether that applies here to our persistent violent felony offender statute, does it? We haven't seen any authority on that yet.
on the Erlinger specifically, or in the Apprendi line. Well, I mean, in the Apprendi line of cases, I think the Court of Appeals has found that our PVFO statute holds up. It's
Right.
determining the fact of a prior conviction. I apologize. I didn't know that the First Department had decided a case last week. I don't know the facts of that one. But I believe there was a First Department case called Stanton that I cited to in my brief that discussed the preservation and the decline to review on that when the defendant, like here, had admitted to the predicate status.
Yeah. I don't think anyone's gotten to the merits of it. It's like Bruin, it's just always unpreserved at some point.
Yes,
He's got to opine on the merits of Bruin and hear the same thing, but you say this is not the right case for us to reach out in the interest of justice to.
no,
address
Justice
that.
Lindley, I don't. And I do think it's sort of analogous to Bruin. In that case, the Court of Appeals, this court repeatedly waited until there was a developed record to review that case. The defendant here had the same opportunity to advocate for his interpretation of the statute as anyone else, and should have raised it at the time when the lower court could have addressed it, the people could have addressed it, and would have given this court a proper record for reviewing it. And with respect to the predicate statement, I acknowledge that the statement doesn't mention the prisons that he was incarcerated in for the second conviction, but he didn't dispute or raise this issue below, and I don't think he should be heard on it now, because had it been raised in a timely manner, the people would have just filed a corrected statement. And also I believe Edwards, the case that defendant relies upon, this court remitted because there was no statement filed whatsoever. There was a statement here, and it would be our position that substantial compliance was achieved here. The statement listed all of the felonies, it listed the tolling periods, and then defendant admitted to that at sentencing. It's our position that the interest of justice wouldn't be served by reviewing this unpreserved claim. Unless the court has any other questions, I'll rest on my papers.
Thank you, Counselor. Case number 343 is People versus Jamil Cox. 343, Appellant's counsel is arguing virtually. Mr. Ash is here for the people. Good morning. Mr. Schifrin,
Can you hear me, Your Honor?
we can. You may proceed.
Thank you. Good morning. Brian Schifrin on behalf of Jamil Knox. On our first point, we argue that the conviction was based on speculation and conjecture, where there were no witnesses to the shooting. There were no witnesses who placed two men together on Wabash Street where Mr. Lathrop was shot. There's no forensic evidence linking Mr. Knox to the crime. There's no inculpatory statements. There's no gun or ammunition linking Mr. Knox to the crime. Even if they were together on that street, we don't know what happened on that street. What we do know is that there's a surveillance video earlier showing Mr. Lathrop acquiring a hammer and following Mr. Knox, and that hammer bloody just found next to him. We don't know if Mr. Lathrop used that to threaten Mr. Knox or someone else.
Counselor, that weapon was found in the head, I think, the victim's, or no, was it the victim's blood on it?
Yeah, the victim's, it had the victim's blood. We don't know if Mr. Lathrop used that as to threaten, and whoever shot him did it justifiably. What we do know is that the people's case was built on inferences based on the inconsistent and incredible testimony of the Jackson brothers. The Andre Jackson and Tony Jackson.
Also two witnesses, though. One witness at that saw your client running from the scene with the pistol. I think he put it in his waistband.
I'm smiling because that witness has actually disavowed but in the people's brief, the witness testified that from a distance, Mr. Manley testified from a distance of approximately 50 yards, he saw a pistol, pistol-like weapon, he saw it was a Glock in the waistband. As the people acknowledge in their brief, pistols eject shells. There were no ejected shells. That's why in the people's brief, they say, well, it had to be a revolver, not a pistol, because that testimony didn't make any sense. Mr. Manley, that witness, we know is a liar, by the way, because
Well, he could be, I think the people would say he might be mistaken with the make of the gun. It might not have been a Glock and maybe he wasn't lying, but I get your point. Would you agree with this that we have Andre Jackson and Tony Jackson were present? The evidence is pretty strong, and I don't think you would dispute this part of it, that the two Jackson brothers were on a porch with your client and the victim, and a fight broke out between your client and the victim, and your client punched him in the face.
well,
Do you?
I agree with everything up to their last sentence, because Andre Jackson testified that Mr. Knox punched Mr. Lathrop and made a threat to him. Tony Jackson did not testify to any such punch, and that's important.
All right, so, but you agree up to the point of the punch. They were all together at that location at that time, right?
Absolutely. The problem is
Your client's cell phone data puts him within 30 yards of that phone. Now, maybe somebody else had his cell phone, but your client was there close to the cell phone tower that puts him within 30 yards of that house, right?
there's no dispute, just so it's clear, that Mr. Knox and Mr. Lathrop and the two Jackson brothers were together. But what's critical is that Andre Jackson, as Justice Lindsay just pointed out, testified to things that Tony Jackson, who was there, didn't testify to, a punch or a threat. And then at trial, 21 months after the shooting, for the very first time, Tony Jackson claims that he observed during this interaction, when they were all together, that Mr. Knox dropped a revolver and then picked it up.
Silver revolver that's not black like Mr. Manley, and you make that point pretty well in your brief, but I'm just trying to get what you acknowledge and what Mr. Kasparek didn't dispute below, that your client and the victim were on the porch shortly. They were together in close proximity, a block and a half or so from the murder scene, close in time to the murder, right? They were together. Doesn't mean that he committed murder. Could have been somebody else, but at least you're giving me that much, right?
Absolutely, yes.
Okay. And then your client leaves. He's wearing a black backpack. He leaves the Jackson porch. And Mr. Lathrop, the victim, leaves the porch and hops on a bike and goes through the plaza there at Goodman Plaza, right? You're with me so far and all that.
And Mr. Lathrop acquires a claw hammer and continues to follow Mr. Knox while holding that hammer.
He just happens to find one laying there.
It looks like he might have gone to a store. It's unclear how exactly how he acquired it, but there's no question. At one point, he has a hammer. He's holding a hammer, and that hammer is found, as Justice Keene pointed out, next to Mr. Lathrop when he's dead.
Would you agree with me that your client, the video show him heading to the street, 7th Street, I believe it was, Wabash, in that area where the homicide took place?
Yes.
Okay, and you agree that Mr. Lathrop is seen trailing him on a bicycle with a claw hammer to that area?
Absolutely. And the question is, what happened on Weber Street? Were there other people there? Did someone else see, for instance, Mr. Lathrop threatening Mr. Knox into seat, and Mr. Knox ran away because he's threatened by this guy with a hammer? We don't know.
Our video camera cuts off at the critical time and place. So your theory is that, the victim was there because he got shot and killed there. Absolutely. Your client was there moments earlier. Your client, but maybe your client just had a dispute, allegedly, according to the Jackson brothers, but maybe the Jackson brothers are lying. And nobody else is seen on the street, but there could have just been some random person who had a beef with Mr. Lathrop and just came up and shot him anyways.
All right. But no one else has been in the street. Just so it's clear, the witnesses who were in the area, none of them claimed that there was no one else on the street. They claimed that they didn't see someone from their vantage point. No one else who testified was on Weber Street at the time of the shooting. And we don't know if there was if we don't know again if Mr. Knox was threatened by Mr. Lathrop, if someone else was threatened, if there was someone else there who was friends with Mr. Knox, who saw Mr. Knox being threatened, all we have is speculation about that. The Court of Appeals recently, and this past fall, in People versus Bach, made it clear that the appellate division in a weight of evidence analysis must set in a circumstantial case, and I'm quoting, must satisfy itself that the inference of guilt is the only one that can be fairly and reasonably drawn from the facts, and the evidence excludes beyond a reasonable doubt every reasonable hypothesis of innocence. Over here, you have gaps. And I'm going to go back to something. I'm sorry.
Do you agree that Mr. Ordarno, who was driving that green Honda, like a taxi driver, he identified your client as the person he picked up on Wabash Street? Do you dispute that it was your client that?
No, I do not.
Okay, so he gets into the car right close to where it was, and it takes him to his house. So in your view, essentially, this is a People versus Preston Carter probably case.
Exactly. There's a good reason to suspect that Mr. Knox might have been involved. That's not sufficient. And I want to go back to something Justice Keene said when I said that Mr. Manley was lying. He was lying not necessarily about his belief it's a pistol. That could have been a mistake. I apologize. Justice Lindley said that he was lying with. He's a liar because he was asked repeatedly about his unemployment insurance for a conviction. He denied it when he pled just months earlier. He was on probation at the time. He was shown at trial his signed statement admitting unemployment insurance fraud, and he still denied it. That is not a credible person. You wouldn't take directions from that person. You don't convict someone of murder based on that person's testimony. We have a gap here. Is it possible that Mr. Knox was involved in this crime? We don't know. He was convicted of manslaughter. We don't know the circumstances. And the people point out in their brief, this was a non-jury trial, not a jury trial. This court has repeatedly reversed on weight of evidence analysis convictions in non-jury trials. In People versus Gonzalez, 2019 case, Justice Lindley, you were on that panel. It was a manslaughter case, reversed weight of evidence analysis. More recently, in People versus Panda, 191, 83rd, 1409, reversed weight of evidence analysis in a bench trial. The people are correct. A non-jury trial verdict is treated the same as a jury verdict, which is this court has the authority and the duty to conduct weight of evidence analysis. There's a gap in the proof here.
Right. I think what Mr. Ash is going to get up here and say is that Judge Bailey Turner heard the testimony from the Jackson brothers, and it's a very important testimony. She believed them, and it's difficult for us in black and white transcript to say whether they were telling the truth or whether they were lying. But their testimony, if they're telling the truth, is pretty probative. It's not conclusive, but it's pretty probative. If what they say is true, that is incriminating, to say the least.
The problem is, and you keep saying what they say, but what one Jackson brother says is contradicted by the other one. Andre claims a punch and a threat, not Tony. Tony claims to see a gun, not Andre. They both can't be right. You have to take parts of one, parts of the other, put it together, stitch them together, fill in gaps. That's not the way you convict someone of a serious crime of manslaughter. If Tony Jackson had told the police, as he claimed he did, and then that there was a gun at the time of the shooting, and then maybe that'd be different. Instead, here the district attorney, prosecutor in this case, said to the judge, there are no such police reports, and the trial court said, I'll take that into consideration in weighing his testimony. He first made that claim of seeing a gun at trial 21 months after the shooting. That a testimony and claim not supported by his brother. So when you repeatedly say Justice Bailey credited them, which them? Andre, when he says a punch, Tony doesn't say that. Tony, when he says a gun, Andre doesn't say that. That's why I repeatedly say what we have here is speculation and conjecture to fill in gaps, and that is arguably, not arguably, that's why that's not proof beyond a reasonable doubt. That's not sufficient to base a manslaughter conviction.
Right. Thank you very much, Councilman.
If I just
want to move to another point?
Yep. If I briefly address point two.
Sure.
In point two, we're raising the very same claims that were raised at the Court of Appeals in People versus David, which the Court of Appeals described as raising meaningful questions and significant questions with respect to the constitutionality of New York CPW statutes. But in David, the Court of Appeals held they couldn't consider those claims because they're not preserved. In this case, 6 days after Bruin was decided at the trial court, Mr. Knox's counsel made a motion on the very grounds I'm raising now, and was considered on the merits, and what held it was standing. That therefore, this was a preserved claim, unlike David. And by asking this court to reconsider the recent holding in People versus Davis, I know the two members of the panel in Davis are in this court. In Davis, and rejecting these claims with no discussion, the court, the panel cited People versus Mancuso, People versus Cabrera, and People versus Joyce as the justification for denying the claims raised by Mr. Davis, which were the claims raised by Mr. David and by Mr. Knox. The claims raised in those three cases as to why the CPW statute was unconstitutional were very different than the claims raised in these three cases. The claims raised in those cases, cited and relied on in Davis, were the very claims that the Court of Appeals rejected last year. They're not the claims that were raised in David. They said that left as an open question, and therefore we're asking this court to, again, read the records in Mancuso, Cabrera, and Joyce. You'll see that in fact those claims were never considered, never raised, and therefore this court should consider anew the argument that it's improper to make it a crime to possess a handgun outside the house without requiring the people to prove the person is not licensed, and it's unconstitutional to make it a crime to possess a handgun and to presume intent to use it unlawfully when possession of a handgun is constitutionally protected. For those reasons, we urge that the conviction of the book be reversed.
We agreed with you on the Bruin argument with the CPW second. Would that have effect on the manslaughter conviction?
No, it would not.
And he got concurrent time?
Yes.
Okay. Thank you very much.
Thank you.
Good morning, Your Honors. Ryan Ash for the people. I think, Your Honor, you pretty much have me figured out at this point. You know what I'm going to say on the weight of the evidence.
Well, you say to the fact that one Jackson brother sees a gun, the silver gun out of the backpack. His other brothers in the same porch doesn't see that. One sees a punch, one doesn't. What's going on there?
Right. I think that ultimately that testimony is not logically inconsistent. There's multiple witnesses there. They see different things. They didn't see the complete opposite of one another. They provide a full picture of what actually happened. One witness is watching, one witness sees a punch. The other one doesn't the other brother isn't asked, did you see a punch? And he said, no, absolutely not. There were no punches thrown. That wasn't the testimony at all. And here, the simple fact that one brother testifies as to more facts than the other doesn't mean that the other brother's lying or that brother is lying. I think when you look at all the testimony in a row, it paints a logical picture of what happened here. There was an argument. There was some sort of fight or a scuffle at some point, escalated. And
there's a threat to shoot the victim in the face by the defendant?
That's what the testimony
from which brother said that, or both?
I'm not exactly sure which brother said that.
But not both.
I believe only one brother said there was a threat. One brother said there was a gun, and one brother said there was a punch thrown. And there's two brothers, so one of them testified to two of those things.
He does have kind of a good point. It's like, how are these? I don't know. It sounds like they were drinking and smoking, right?
I think it happened pretty quickly. I don't think it was a long, drawn out, altercation where people are taking their phones out and recording and have something to look at. It's just there's friends.
I mean, look, people who are, if they're concocting a story, you'd think they'd be a little more consistent too, as well.
I'm not going to argue that to you, Your Honor. But that kind of actually makes sense in a way, because if you take any one of these witnesses out, there's still a logical conclusion as to what happened here. Even the surveillance footage isn't absolutely necessary to proving legal sufficiency in this case, because we have witnesses who testified that the defendant was there fleeing from the crime. And there were two witnesses who testified that, at least. So if you take a single witness out, you even say this witness is incredible as a matter of law, that doesn't affect the legal sufficiency regardless, but also the weight of the evidence as we would submit.
We got the different color guns, mainly.
Yeah, the different color guns is kind of an interesting point. There's the one witness, I believe his name is Mr. Manley, who testifies that he believes he saw a black gun, and he makes the claim that it was a Glock, but he was the furthest away of the witnesses. And I would disagree with defense counsel that my rendition of that point, and I think you more accurately got it in that the closer witness, his recollection was that one of the Jackson brothers was that it was a revolver. And that is actually, borne out by the fact that there's no cases recovered at the scene. It doesn't mean that if there was a case recovered at the scene, it would have been one type of gun or not. And if there's no cases, it has to be a different type of gun. It just, these things are logically consistent with one another. The witness who's further away makes a claim that he knows exactly what type of gun it is. But I think he also said he only saw the handle. He saw like a black handle. And so I don't think there's a reason why that would be considered incredible as a matter of law, especially when the court explicitly says that she will take the evidence into account, including on credibility and the witness's, his lack of admission to his.
Right. It looks like Mr. Schifrin saying this is a People versus Carter probably case. Well, he didn't say the word probably, but I'm saying it is that. So what if he's probably guilty? That's not proof beyond a reasonable doubt. You're saying proof beyond a reasonable doubt does not include mathematical certainty. So it's not a mathematical certainty you would acknowledge. So it's somewhere between probably.
I would say it's
certainty, and is it enough?
It's right there next to mathematical certainty. The only possibility is that there was somebody else that no witnesses saw who essentially snuck up, was not seen on surveillance footage, wasn't seen by the people who actually gave defendant a ride out of there, who managed to, for lack of a better term, assassinate Mr. Lathrop during this fight, while he's apparently in a fight with defendant on this particular street where we know defendant is. And that's much more, I believe, the cases of People v. Isaac, where they have this, sentence in there about like, what are the chances that this someone else shows up at the same time as defendant's there and shoots and kills the person. And I don't, we're always supposed to avoid the idea of giving percentages of the numbers of things. So I don't really like using the term mathematical certainty. I do believe the proper term here is beyond a reasonable doubt. And that's what we would argue the evidence bears out.
Right, thank you.
If you don't have any further questions on the Bruin issue, I'd rest in my brief.
Case 344 is already argued with 339, so we're going to go down to 351, Beavers versus Beavers. Ready for counsel to have a seat here if you would. I'm just asking her to wait till you're all settled. Yeah, no, that's fine. Take your time.
Good morning. If it pleases the court, Rebecca Const on behalf of the appellant father. This is a case where this father is attempting to maintain contact with his children, and we argue that the family court erred in finding that the best interest lies with the mother having sole physical and legal custody. There were significant changes in circumstances, such as the father being denied visitation. The mother wouldn't give him phone numbers. He had to search through directories to try to find phone numbers to maintain contact with these children. The mother was not allowing the children to fully engage in the reunification therapy that was required by the court. She was not being upfront and vaccinating the children. She was frequently changing medical providers without discussing it with the father to attempt to delay that vaccination, which had been required by the court. There were times when the father needed police intervention in order to actually have his visitation with the children. And there's active alienation on the part, a pattern of active alienation on part of the mother. One such example was the incident at the dojo where she went and told the dojo owner that the father was a threat and that he shouldn't be there, which was done right in front of the children, which just perpetuates that fear and that, there's something wrong with the situation. It's very unclear from the record why, after requiring reunification therapy, the judge took such a negative view on what the reunification therapist came up with, that without more active engagement by the mother, and with the situation going as it was, that these children were never going to unify with this father. He acknowledges his past bad acts. He did follow through on what was required of him. I'd like to clarify that he was assessed for sex offender therapy and was found to not be a threat. So I just wanted to clarify that a little bit.
Which child is he seeking at this point?
So
He's got one that is,
At this point, there's three girls. The oldest one was never part of this. The second oldest one has aged out. That third oldest daughter is 17 now, so she's getting really close to aging out. But the son is only 12.
right,
Yeah,
nice.
yeah. The son is still 12, so he's got some time that he'd like to be able to maintain.
So
that
is this
contact.
really about the son then?
At this point, I mean, he would love to have any involvement with the daughters, but at a certain point, he realizes that she's going to age out and it's going to be her decision, and the court's not going to have much say on it anyways. But he's been denied since he hasn't had any visitation or any contact with the daughter since I think August of 2022. So he's been denied all this time.
Right, in the time she turns 18, August 8th of this year, so I get it. There's been no allegations of sexual abuse against this man. He's committed no crimes.
There was a finding of inappropriate acts.
Touching, like
Yes.
hugging,
Yeah.
uncomfortable hugging,
Uncomfortable touching, yeah.
but no,
And he
No.
followed through on whatever was required of the court. And like I said, he was fully assessed for the
Right.
sex offender
he's never
therapy
been
and
charged with a crime. He's never done time in prison,
no,
has a job,
yep,
there's no corporal punishment.
no,
And the bothersome thing to me is, okay, I get he loses, that the mother gets sole custody. His visitation with the daughter, the one daughter that we're talking about, is zero.
yep, nothing,
Her
no
name.
phone calls, nothing.
We
The
see
mother- He had
people-
to search through church directories to try to get a number for this, so.
We see people coming out of prison who have taken other people's lives who are getting visitation, and this man who has never laid a hand, I mean, I know that the allegation is, well, he hugs me and that makes me uncomfortable. That's the worst of it.
Mhm.
And now he loses all contact
All
with his daughter.
contact, yep. And he
That to
continues
me
to
is-
try, and I mean, he went through the steps, he tried the reunification therapy, and he just keeps hitting roadblocks.
And
And-
you don't know what the in-camera says, I do.
Mhm.
That is what bothers me, but as you said, the child turns 18 in August and your client seems to have given up on that and he's gonna have to
I
mend that
mean,
relationship.
he doesn't want to give up on it, but he understands the reality of it. Yeah,
Legally.
legally, he understands.
He
the
doesn't want
reality.
the police to go force her in handcuffs to his house.
No, and he
Just the worst.
continues to make concessions. There's been subsequent things that have occurred, and he continues to make concessions because he's trying to not further harm the kids. So he keeps, she keeps filing against him and he keeps reducing
So
his time.
Tragic as it is, we're not here to talk about the daughters. He's
Right,
got to try to do something. They're adults now or will be, and he's got to
yep.
try to mend that. We're talking about the
The
boy.
son, yep.
And he does have visitation with the boy. The boy
He
doesn't
does,
want
but
to
it
see him.
keeps getting narrower and narrower and narrower.
So your client wants joint custody of the boy and shared physical residence? And that's what we're deciding here today,
Yep,
or considering.
considering, yep.
Uh,
At the bare minimum, more say, more contact, more, help with maintaining this. So he's not constantly up against these roadblocks with the mother alienating the kids.
Is anything else pending in family court now? Or the new-
They just recently, a couple weeks ago, did a new order came out. It was, it modified the August 3rd, 2023 order. It was done on consent because the father just doesn't want to keep dragging the kid into court. So he did consent to reducing his visitation yet again to try, to not keep bringing up these bad memories and to appease the mother who keeps filing against him. So there was just a recent one.
So what is the new order? Do you know?
The new order, it continues with the mom with sole custody, but it reduces the father's visitation.
Kid to return on Sunday as opposed to Monday? Is that what it was?
So he'll have parenting time every other weekend from Saturday, 1 p.m. to 8 p.m. and Sunday from 1 p.m. to 5 p.m. So I think it reduces any overnights. And he has him, you know, during the day on Saturdays and Sundays. So like I said, he keeps trying and he keeps being met with roadblocks and keeps reducing it.
Still paying child support for the child for whom legally he cannot even see?
Yeah.
All right, anything further?
Nothing unless the court has further questions. The rest on our brief. Thank you very much.
Thank you.
Jeffrey Perry from Ms. Beavers, Your Honor. One moment ago, I didn't think I had much to talk about. I think I've got quite a bit right now. Judge, he was charged with a crime. He received an ACD. Why that should be, I haven't the faintest idea, but he did.
What was the crime?
I was not the attorney below, Judge, but I have it in my brief that in fact he was charged with a crime.
But he was not
Was he convicted? He got an ACD. Judge, I realize I'm an old-time criminal defense lawyer. I realize where that puts us, okay?
Right.
But he also lied to police officers about it. He had his own kids recording his conversations because dad can't be trusted. This is not quite the rosy story that my colleague has depicted.
The allegations for the criminal charge were he snuggles with them and they didn't like being touched. It seemed like it wasn't touched in a sexual way, but he's an affectionate guy. That seems to have been his point of view. Their point of view was respect our boundaries and we don't want you touching us. Right? I got that right?
No, sir, I don't think you do.
It was more than that?
Judge, I'm a first-generation Italian-American. We touch a lot, but we don't touch that way. Your Honor,
What way was he touching her?
well, Your Honor, if we have a consensus amongst the daughters that the touching was creepy, I think we've got a problem. Now, Your Honor, I want to be very, very clear with the court. I have never once, even in my own practice, had somebody come to me, well, very frequently, if people come to you and say, I don't want my spouse to ever see these kids again. You get it all the time. I have explained to people, I don't know how many times that these are his children too. He certainly has a right to rehabilitate a situation with his kids. I'm not suggesting that he doesn't. To give him carte blanche on that, Your Honor, that I can't agree with. There is some very, very suspicious things going on here at the very least.
Right. Again, we're in a difficult situation because I can't reveal what I've read from the girl's allegations in camera. And I don't believe you've seen them either, right?
I have not, Judge.
But that would have been the place for the girls to explain, why will you refuse to see your father? What has he done to you? That would have been a good place,
of course,
to explain that. And that's all I can say. But we have, how about the boy? The girl, the father is conceding it's over. He's not, the girl's going to turn 18 in August. He's not asking the court to force her to come visit him. That's done. But so now we're dealing with the boy.
Your Honor, if I could just give you my perceptions, and again, I was
Sure.
not the attorney below, but if I could just give you my
That's fair.
perceptions.
Yeah.
This thing has gone on forever. And Your Honor, there is some evidence to the effect that his relationship with his son is deteriorating. And I would, my own opinion, Judge, it looks to me like it's because this thing is going on forever. I mean, it looks like things are going from bad to worse. Judge, I don't.
You're saying the visits aren't going well with the father, and that's what's causing it.
I'm sorry, sir.
You're saying the visits aren't going well with the son and the father, that's what's deteriorating? Or is it because these court proceedings are going on? What is causing?
Well, I was bringing it up in context of the court proceedings, but Your Honor, you mentioned the scene at the dojo. It was handled very inappropriately. He goes and gets his brother, brings him back here, and now we're going to film this. Judge, that was not necessary.
Well, he wanted to go watch his son do karate.
Yes.
He just wanted to watch. I mean, a lot of parents go watch their kids play basketball, play soccer. I'm not sure that's the crime of the century, but what we have here now, where I think I would agree with you, the breakdown in the parental relationship is joint custody is not possible.
I can't imagine how it would be, Judge.
It's not possible. So we're just talking about time. He gets every other weekend, right? And the father wants a little more than that. That's what we're here for today.
It would seem so, Judge. And again, I would fall back on my earlier statement. I have never once advocated that someone should never see their children again. I mean, even people in prison have a right to see their children. On the other hand, Judge, there was a lot of this that was self-inflicted.
Yeah.
Counselor, these children are homeschooled.
That's my understanding, Judge. Yes.
Okay. And do they have outside contact with other people other than the mother? I mean, is the mother such a dominant person in their lives that?
Your Honor,
that
I
there might
have.
be a danger that, that they're controlled by the mother?
Again, I can only give you my perceptions, Judge. She does not seem terribly dominant to me. Actually, she seems the opposite. But that's just my perception. And obviously, I'm just appellate counsel here. I've only met her on a couple of occasions, but that's my perception. Your Honor, I can see that people can become extremely protective under these situations. We've all seen it. I'm not going to lie to the court. But as to whether or not the kids have contact outside the home, it's my understanding it's an extremely religious atmosphere. I understand that the church plays a big part in their social life. And beyond that, Your Honor, I really can't comment, except that both parents are apparently very religious.
Anything further, Counselor?
Your Honor, I hope I'm being some kind of a help.
It's very much, very helpful, and we appreciate your advocacy.
If I can add this one brief, I guess you could call it an anecdote, Judge. 35 years ago, when I was a brand new lawyer and I had no clients, I briefly attempted family court.
Didn't go back in 35 years?
Didn't go back again, no. So
You're here now,
I
you did
meant
a very
it when
nice job.
I meant it when I said, Judge, I think it's in the best interest of the children here. This thing's got to end. This is going to be over. So anyway, thank you very much for your time.
Thank you. Ms. Cagnina?
Morning, Your Honors.
You-
Susan Maris, attorney for the male child. May it please the court. One thing I want to think clear up, Judge, it was the oldest girl who the father was charged with by the state police with forcible touching and endangering the welfare. That was ACD'd. Child Protective Service indicated the father for sexual abuse and inadequate guardianship of that same oldest daughter.
Dismissed. The charge dismissed?
It was ACD'd.
That's a dismissal, right?
Well, yes, but
Adjournment in contemplation of dismissal.
yes.
Dismissal, the last word I think the father would be focusing on. But anyway, we get your point. There were some allegations
He
of
still did the act.
the act as described by the child in camera.
No, I did not read the in camera. I'm the attorney on the appeal.
Right.
Those two children, their biggest complaint was the father was violating their personal space.
Right. Hugging, cuddling, like during a movie. What's the not a
But
good
here's-
idea, I guess, but I mean it's
The issue is those
not
two
just-
girls know what he did to their older sister.
allegedly. But,
Allegedly,
yeah.
all right, but they have an understanding.
right.
So if they know the father and they know it from their sister allegedly did something sexual, their normal reaction would be stay away, don't touch me.
Right.
And besides that, the father would always say, I'm your father and I can touch you. And he lied to the sheriff about that. If the girls didn't have that recording, it would be their word. He said, I didn't touch them, when in fact he did, just to prove that he's the father and he could touch them. But more importantly, procedurally, Your Honor, this order filed and entered March 25th, 2025, which was on stipulation, moots this appeal. It's a superseding order. The law is well settled that a superseding order moots the appeal.
What's the date on this? So this is an order you're saying, the
It-
appealable order, August 3rd, 2023. There's a more recent order. What's the date on that?
March 25th, 2025, and the order specifically says, order modifying August 3rd, 2023 order, which is our order on the appeal. I can give it to the court.
Wait, was there a motion to dismiss the appeal as moot based on this?
No, this is so recent.
Well, that's fine. Yeah, I'm not saying
Yeah.
you had to bring a motion, but a post-argument submission on this might be in order.
I will do that, Your Honor.
Thank you.
And as for the merits, unless there's any questions, I'll rest on my brief.
Thank you so much.
Thank you.
Right, our next case for oral argument is number 353, People versus India Bar Blunt. Morning.
Morning, Your Honor. Stephanie Stair for India Bar Blount. Briefly, I will address point one. The waiver in this matter was invalid because of Ms. Barblount's intellectual disability. During the oral colloquy, she was not asked about her literacy or her education level or disabilities that affect her understanding of the proceedings. The record is clear that she has an IQ of 73 and severe lead poisoning, which led to developmental delays, learning disabilities, emotional disabilities. And in fact, on page 119 of the appendix, the school psych evaluation showed that she had difficulty learning new vocabulary, answering factual questions, comprehending oral and written directions, acquiring general knowledge, and using prior knowledge to perform activities and understand new concepts.
Right, so this waiver, just so we can move along a little bit. You don't challenge the wording of the waiver.
No.
It follows the model colloquy.
Correct.
If this were given to a defendant of average intellectual means, we have a airtight waiver.
Correct.
Your point is that due to lead poisoning and other issues, your client's intellectual capacity is a little bit lower, and extra care needed to be exercised by the trial court to ensure that she knew what she was giving up with the waiver of the right to appeal.
Correct. I would submit it substantially lower, and the mechanistic yes or no questioning.
Are there cases, you cited the cases that dealt with intellectual capacity, but that was in a Miranda context. Without, here she had two lawyers and her mother in the courtroom. Do you have any cases that deal with a different, heightened sense, a heightened standard of voluntariness and duty on the court for a waiver of the right to appeal?
Not specifically, Your Honor. The closest I could find was that Miranda case. But we submit that the right to remain silent is no less important than the rights that she was waiving. So the analysis should be the same when reviewing the totality of the circumstances on that Miranda waiver.
So there'd be no possible way to get a valid waiver from her. Like no matter what questions you ask her, in your view, the way you write it in the brief, is she's not going to be able to comprehend what's going on here.
I don't know, but I know that the way it happened, I don't see a way that she could have possibly known what she was waiving. So
if we agree with you and send it back, I mean, the case doesn't get dismissed, it's just the charges are reinstated, correct? And she cannot plead guilty under your scenario.
I think extra care, as Justice Lindley phrased it, would be necessary, given.
Well, I think he asked you that, but I don't think you really stated how it could be a valid plea, which is not an unreasonable position for you to take, but given, her condition.
Correct. I think,
Excuse me, didn't she have a lawyer there with her who went over the colloquy with her and reviewed it in the court? Talked to him, wasn't her lawyer right there? And wouldn't that lawyer be in the best position to know whether she understood what he was saying to her?
Yes, but as covered in the rest of my brief, there is an ineffective argument.
She had two lawyers, but I guess I was wondering the same thing Justice Greenberg was wondering, if she's intellectually incapable of understanding the nature of a waiver of the right to appeal, then it would seem to follow she's incapable intellectually of entering a voluntary guilty plea.
That may be possible.
And then we go to trial on this. It's a murder charge.
Originally, yes.
She goes to trial looking at 25 to life on murder.
Mhm.
She got a reduced plea, and what she got 14
Yeah,
years.
14. Mhm.
You wanted to go to trial on murder second?
Well,
I mean,
I wanted to be
dismiss it
resentenced.
somehow, but
I mean, obviously the bulk of my brief is asking for resentencing under various different avenues.
Gotcha. Couldn't she bring, by the way, one of the arguments is that the lawyer was ineffective for bringing up the Domestic Violence Survivors Act at sentencing?
Right.
Couldn't that be done now?
Yes, that's what I'm doing now.
Well, no, I'm saying in a separate proceeding.
It could probably be addressed by a 440, but your honors also have the ability to address that. I feel that the record is more than complete in terms of the mitigation.
Right.
That would be presented under
And that's a
DVSJ.
legitimate claim. I mean, this poor girl was the actual murderer was her boyfriend, had a child
Correct.
with her. And there seemed to be some domestic abuse going on there. And
More than some, yes.
perhaps some coercion and duress in the crime itself, maybe not rising to the level of an outright defense, but those are factors that, so we're gonna take a look at that, that issue. Is that barred? If we find the waiver valid, are we precluded from getting to that one?
I think in the interest of justice, you can reach it. I would ask you to reach it in the interest of justice.
That deals with preservation. If something's, this is a waiver, I don't know, but if we have interest of justice, if it's barred, but we will, we'll get on Westlaw and take a really close look at that.
Right. So the way that it is raised is as an ineffective claim. And then in the alternative, asking you to resentence her under DVSJA. So the 0.3 is ineffective assistance for not having raised it. In that the trial counsel did ask for YO sentencing, but YO and DVSJA are not mutually exclusive. And as you've already acknowledged, the record has ample evidence about the abuse that this poor girl has suffered at the hands of her co-defendant. And there's just absolutely no reason to not have requested it. So the initial ask is that you find that it was ineffective for trial counsel not to have asked or for alternate sentencing, and then taking the step further to resentence her given the ample evidence in the record that follows the 3 factors under the DVSJA sentencing. Very briefly on 0.2, we just our position is that accomplice liability is not contemplated by a plain reading of the statute for adolescent offenders, that the case should have been removed to family court. With respect to that, the people's entire position ignores the dynamic that existed between Jason and India and presupposes that she had any sort of free will, which we submit she did not.
Is that Boyle case, that recent Boyle case from the first department that people rely on, is that off point?
Your Honor, unfortunately am not familiar.
The issue here is causation.
Right.
She lured the victim in to stop, and then her boyfriend murdered the guy. So the question is, did she cause the murder? She didn't pull the trigger. She wasn't armed. That's really the issue, causation for this youth part issue. Counsel cites this Boyle case from the first that seems to support her position on causation. It's so I was just curious your view on that, but we can move on. You have a harsh and excessive issue as well, I believe, right?
I do, Judge. I also have, I'm not gonna, just very briefly, I want to go back to 0.3. I know everyone is very aware. I want to make Your Honors aware that her family members are present today. And that is part of my brief, that she is from a very close-knit, supportive family. Jason was the only reason she was involved in this. And a sentence under 7002 would be unduly harsh. India Barb Blount is the reason DVSJA alternate sentencing exists. If it doesn't apply to her, I don't know who it applies to. Before I get to harsh and excessive, we do ask also that the court consider the YO denial. I know an armed felony makes her ineligible in the first instance. However, mitigation was shown both that bears directly upon the manner in which the crime was committed and her relative minor participation, but not so minor as to constitute a defense. The statute is an or, but we contend that the record is clear that both are present. And I know Your Honors have all read the mitigation memo, the sentencing memos, pages 107 through 133 in the appendix. I implore you to read it again. India was sentenced to 14 years, which is harsh and severe given the circumstances. Jason pulled the trigger and got 24. Her armed co-defendant also got 14, same exact sentence, much more culpable, no history of DV. Her statutory minimum would be 3.5. And we would ask that if all the other arguments fail, this court would modify her sentence.
Right.
If there are no other questions, I would rest on my brief.
Thank you very much.
May I please the court, Regina Harper for the people. I would like to start with the waiver of appeal. The waiver of appeal, the record here is very clear that it was a valid waiver. The court conducted the oral colloquy to determine that the defendant understood the rights that she was waiving, including the waiver of appeal. In court, she also signed the actual written waiver that defendant is not challenging, that is insufficient for any reason. So this valid waiver, and I would also like to point out that prior to coming to court to accept the negotiated plea, she also spoke with her attorneys and the offer was explained to her. And that's also on the record, that she also stated that she was satisfied with the representation that she received. Furthermore, I would like to point the court's attention to the fact that she did understand the proceedings, and that is clear on the record. When she did not understand something, she would ask question. When the court explained to her the consequences of potential deportation or removal from the United States should she not be a citizen, she actually did ask a question. I don't understand. And this was explained to her on the record.
I'm not sure that question is helping your cause any, but.
Your Honor, it does show that she understood the nature of the proceedings. When she didn't understand, she could actually ask.
Okay.
So that's what I'm getting at, Your Honor, that she had ability to ask and clarify for herself if she didn't. So the valid waiver does preclude the court's review of all the claims in this case. Certainly, the sentencing under DVSJA is something that was not preserved, and it is being raised on appeal under ineffective assistance. I would like to point the court's attention to the fact that this case originated as a murder in a second degree. And as the court noted during the trial court proceedings, that she was the one who set in motion the events that ultimately led to the death of the defendant. I also cited in my brief on page 19, People versus Riley. It's the third department's case decided in 2023 that specifically is on point, and it says that the counsel is not ineffective where he does not seek a sentence under DVSJA. Also, by reviewing the record, it becomes very clear that even should the trial counsel even ask the court for this sentencing, this motion would not have been successful. And that is very obvious from the reading of the actual sentencing minutes and the comments that were made by both the court and the people in this case.
Would you agree the door's not closed on the DVJSA, if I'm saying the initials right? You can do it at sentencing or you can do it later.
She can certainly bring a 440 motion regarding that. The law, I believe, allowed her.
Even with a valid waiver of the right to appeal.
Well, the waiver of appeal, I believe, still precludes her from appealing all the claims, but this would be a 440 motion.
Right, that's my point. It may preclude her here, but not on a subsequent proceeding.
Yes. Regarding the ineffective assistance, I still believe that this argument would not have been successful. I would also like to point out that this was a reduction from the original murder charge that exposed her to up to 25 to life. And as a result of this reduced plea and sentencing, because the people did ask for a specific sentence to be imposed between 10 and 15 years, and the court ultimately imposed a 14-year sentence. Regarding other points in the brief, unless you have any questions, I would rest on my brief.
Thank you.
So I do have one question for you, counsel. Is accessorial liability in the legislative history of the raise the age statute as a factor for keeping an adolescent offender in youth park? Is that in the legislative history?
So it
As
is
one of the factors.
right. So it's not really clear. In my brief, I do cite a case that talks about causation. It is Clark versus Boyle. So that in that case, the court decides what causation is. And one would cause serious injury or death to another person when they set a series of events in motion. And this is exactly what happened here. So as to causation, that would be my position. Also, the cases that were cited by the defendant here, they are the cases that were decided before Clark. So the Clark makes it clear that you don't have to be the sole reason for the death or injury, but you have to set the events in motion, and that's what I guess that's the main component of the determination.
We appreciate your time this morning.
Thank you.
Case number 356 is Kimberly Salter versus Meta Platforms Incorporated. 356. Honors, good morning.
Good morning, Your Honor, and may it please the court. As I was preparing for our discussion, it occurred to me that point 4 in our brief on jurisdictional discovery really ought to be point 1. And in fact, it should have been the only point, because we can't lose sight of the fact that we're at the pleading stage. This is the earliest stage in the litigation. Right? We haven't really had a chance to do anything except file a complaint that is an expansive, thorough complaint designed to approach the problem with regard to holding people accountable if they're primary actors and purposeful activities.
So under the Williams and B. Miller case, you would then now claim that you had a sufficient start to warrant further discovery.
It's even better than that. Bud Williams was my client. We had that case at the Appellate Division when Justice Peredato wrote at that time, the case should not be dismissed, go back to trial court for discovery and for depositions, which we did, which is exactly the case here, except our allegations were pled with Bud Williams' case in mind. We know Williams versus B. Miller at the Appellate Division level. My good colleague here cites the one at the Court of Appeals where one of the defendants was let out in jurisdictional grounds. But we ignore the fact that at the Appellate Division, it said, go back and do your discovery. And Justice Marshall was reversed in its entirety.
Right. Well, I'm glad you started with jurisdictional discovery because that was on my mind as well. And I read Justice Farrelletto's decision there. It's a little cryptic, but she mentions at the end, in way of passing, that Mr.
Waldrop and Clark.
Waldrop and Mr. Clark are going to be deposed because the corporation is still in so far. Did you take that as suggesting that the denial was without prejudice, and depending on what emerges from those depositions, maybe we can revisit this? Is that how you read that?
I didn't take it that way, to be perfectly honest, Your Honor. I did not. And
what was the purpose of her mentioning that? I mean, you probably have statute of limitations issues as well. So you got, but that she mentioned that for a reason. And I guess you would say it would be unjust if we're going to depose them and we get all this information that would have been helpful a long arm jurisdiction, it's too late. So
Exactly.
why not wait until we talk to them and figure it out?
Why not do it now? I mean, it's judicial efficiency as well.
And isn't it that similar to the Kruger case? Maybe I'm mispronouncing it.
It's
That
Kruger,
same
yeah.
case was indicated where that Denman was the individual defendant they were looking to keep in as far as jurisdiction, personal jurisdiction. Denman will undoubtedly be its principal witness, and we have to come to New York for that purpose. That being so, the inconvenience, because I talk about fairness and due process, he faces, if made a party to this suit individually, is minimal. And as a result, notions of fairness do not require us to shield him from the reach of the long arm
That's
statute.
exactly right.
So I
Mr.
think it's very
Denman,
similar to when Judge Lindley is talking about, Justice Farrelletto's comment at the end of her opinion. It drew me to this comment in Kruger that, again, where's the fairness? We're arguing that fairness and due process is a problem here, but in reality, they're going to have to be deposed anyway.
Eugene Birch Denman was a Texas resident who, as you point out, under the Courtois test, was required to appear for depositions under allegations in that case that were far less comprehensive than the ones that we made. Right now, our pleadings are construed in the light most favorable to the people that I speak for. At this juncture, all I have to do is make a showing. All I have to do is put in facts that may exist to suggest that there's jurisdiction over those two individuals who are the primary actors in selling body armor to an 18-year-old that no person should ever should purchase.
In actuality, then, if the court would consider admitting this for purposes of jurisdictional discovery, that wouldn't preclude the defendants from bringing this same action to dismiss further along lines, because if maybe the jurisdictional discovery isn't favorable to you.
Exactly right. That's what happened in Williams and B. Miller with respect to one defendant was carved out eventually in the Court of Appeals. But that was only after full discovery and depositions. And I didn't do a count of my friends' cases that were cited, but I'd be willing to bet there's a high percentage of cases that were cited by the defense that were post-discovery, post-depositions when they were actually litigated, like you said. I need to know. I mean, we've alleged specific allegations about these two. These aren't people we picked out of a hat. These are people who are primary actors who did purposeful activity in connection with this case. They need to be held accountable if there is something that's of substance that we developed during the course of our discovery. And that's all we're asking for. We're only asking for that based on the case law that exists now that says we're entitled to it if facts may exist to support jurisdictional discovery.
So how would this work? This is a 3211 motion, correct? And so what Justice Montour was referring to, would they wouldn't be allowed to bring another 3211 motion though? It would have to be a summary judgment motion, 3212.
It would definitely come in under summary judgment after we have discovery and depositions. And they'd be able to do that. And who knows what the outcome would be, but we have alleged facts. I mean, listen, we know these Williams B. Miller cases cold. We knew what we had to plead in this particular case, and it's a laundry list. If you look to paragraphs 118 or paragraphs 93 to 101, you'll see specific allegations about these two that render them responsible as primary actors who were purposely engaged in activity that we say was negligent, careless, and reckless.
We have RMA armaments in regardless at this point. But let's talk about the facts that you're talking about for jurisdictional discovery, facts that you might discover if you put them under oath. The facts in the complaint, if you're limited to those, we have for Mr. Waldrop, it sounds like you're tying jurisdiction under 302, either A1 or A3 on the fact that, not the fact that he's a CEO of RMA, per se, but that he's actively involved in marketing efforts. Do I read the complaint correctly and your arguments correctly there?
You've read it correctly, but there is more.
Okay.
There is more. We say that he's intimately involved in the day-to-day operations, that he tests the product, that he markets the product, that he collects the data for the product, that he has.
When you say he tests the products, how does he do that?
Excuse me?
How does he do that?
Yeah, I wonder, but he brags about it on the internet.
I'm not sure he's the one taking the bullet.
Doesn't he personally stand in the shooting range, maybe? That's the understanding I got, was that he stands in a shooting range and he tests this body armor.
He brags about the fact that this will stop all the bullets. And unfortunately and sadly, it stopped the 4 bullets that Aaron Salter, my hero client, hit him with directly in the chest, and he didn't even flinch.
So, but for his marketing efforts. And I mean, any CEO is actively engaged in the product testing and everything. So is there any limit? I mean, would every CEO then be personally? Because we're not talking about his corporation, you already got that. Every CEO can get dragged into court here?
That's a great question. And it's one that obviously you should be concerned about, and I'm concerned about as well. That's why we specifically targeted him, because we were able to demonstrate through a series of allegations contained in our complaint that it was not just reckless marketing, that he targeted, that he motivated, and he attracted people like Denman, these disaffected youths. That's an allegation that we made, that he was directly involved in the sales and the marketing. That's an allegation we made about him. That they failed to implement any screening process. Can you think of a situation where you're on the telephone or on Reddit or TikTok, and there's someone's buying a product like this? You don't ask them how old they are. It's inconceivable.
What if Waldorf, like most corporations, have marketing directors, marketing departments? Let's say Waldorf didn't get involved in marketing, and they got some kid working there doing marketing, comes up with the same slogans. He gets dragged into court in New York here. Under the same facts here, if he works for Waldorf and he does marketing, he's never set foot in New York. He couldn't even pick New York City on a map, but he gets hauled in. Or how about the person who answers the phone and takes the phone call in Iowa, never been to New York? Somebody says, yeah, I want body armor. What state are you from? I'm not from Connecticut. So at the time, everything's legal. Okay, yeah, here, I'll send it to you. Does that phone dispatcher get hauled into New York?
Probably not. But what I will tell you this, Your Honor, is that if I'm investigating that particular incident, and I believe that I can show that they were purposeful actors and primary in connection with that sale, and that sale results in a tortious act in my state, if I could do that through discovery or through depositions, there's a chance that they would. We don't have a fiduciary shield doctrine anymore. That was abolished, that corporate doctrine. Corporate actors now are held responsible for what they do. That's the Chloe case in the Second Circuit in 2010. So your question is one that we did labor with. Actually, we labored with it when we filed this complaint. We wanted to make sure that we could allege sufficient allegations to make a showing that would entitle us to discovery. And we think we did.
How about the agent issue that has been discussed in the briefs, and whether these two officers are agents of the corporation or vice versa, and how does that affect jurisdiction here?
Yeah, that's a very complicated situation, but you see from the case law that an individual can be an agent of a corporation, but a corporation for purposes of jurisdiction can also be an agent of an individual. That's the specific language in Croyder in the Court of Appeals.
And which one? Because it sounds like you're going both ways.
I'm going both ways.
Okay.
I'm going both ways here because I'm just trying to get jurisdiction. I'm just trying to get them under oath is what I'm doing. But you're absolutely right. I'm going both ways.
To get back to Justice Lindley's question, and maybe even in your response was whether or not the person taking the phone call and taking the order would be a stipulation. Is it necessary as far as the jurisdiction? I think all the cases have indicated this, that you have to be a primary actor.
Primary actor with purposeful conduct.
Right. I don't know whether or not this individual answering the phone could be classified under that situation.
You know, there may be some circumstances, Your Honor, I can't think of them right now.
But I think you're going to have to demonstrate primary actor. Here, what you're referencing is that these two individuals obviously were primary actors in your argument.
Yeah, and Corey Clark, you've got this individual who's in direct contact with Denman, directly encouraging the shooter to buy this product as well. The exchanges that they have on Reddit are awful. And it's like they're developing a bromance when they're talking about what they have to do. And the worst part about it is, and the reason I want to get them under oath is when this shooting occurred, right afterwards, Corey Clark deletes. He pushes delete. He doesn't want any evidence of the transaction between him and Gendron because he knows he's guilty. He knows he has knowledge that he was involved in misconduct.
But they say, maybe you dispute this on a factual level, Clark had no idea the person he was talking to ended up doing the shooting was from New York, was underage, and had any plans to create a mass shooting. Do you agree with those facts?
Defies credibility, and let me tell you why. Not only for the reasons we've discussed already, But on January 10th is when the order is put in. It's shipped shortly thereafter. On April 14th in 2022, 40 days before that individual came into our community and killed 10 of our citizens, there's an exchange there where they say, this is genuine. I want to advertise your product. Right? I want permission and confirmation from you to advertise your product. And obviously Clark has to talk to the boss, Waldrop, about it. That's just logical. And so you can tell me that they don't know at that point that they're advertising their product in New York State, or they don't know at that point that he's using the discount coupon in his 47,000 word rant as to what he's going to do before he comes into our community and kills 10 people. I don't believe it. And I think under oath, I'll find the answer out.
And when they shipped it, obviously to an address in New York City.
No question. Yeah.
So they knew that 3 months before.
They had to know that.
But it was lawful at the time.
Not now.
Right. But when the order was placed, it was lawful and the law changed as a result.
Doesn't mean it wasn't negligent.
No, I agree. You can still have a tortious act to give a lawful product to somebody. This is negligent entrustment. So
Happens all the time
we
in our
get that.
courts.
And I think your point in a nutshell is that we have affidavits from Waldrop and Clark that say they have affidavits in the record, they make all these factual assertions. Your point is you can't be expected to just accept the truth of those allegations. You want to put them under oath and cross-examine him, and then we'll see where we stand on jurisdiction.
Absolutely. That's exactly my point. And to go one step further, Your Honor, those affidavits are important for what they don't say. They don't address all of the allegations and say that we were involved in this. They don't address some of the marketing that we've identified as being reckless management. They need to be held accountable. You know, month after month and week after week, we read about these shootings, this mass shootings, this epidemic that we're faced with. And then it comes into our community. And now all of a sudden it's real because it happened in Buffalo, New York. And it was in our schools, in our churches, in our malls before. And we grieve and we say, okay, thoughts and prayers are offered for you. And that's all we do. We're doing more. We have identified the ability to reach into the corporations of these bad actors and bring them and hold them accountable. That's the only way we're going to stop this.
Right, but would you agree at this point, we're not talking about whether they did anything wrong legally, or they should be held accountable. You're just trying to get your foot in the door. You want them in a courtroom, whether they're liable, whether they committed tort. I mean, that's all for another day down the road. You want to at least have a shot at it.
Absolutely.
You want your clients to have a day in court on it.
That's exactly right, Your Honor.
Right. Anything further?
No, thank you.
May it please the court. My name is Mitch Banis. I represent respondents Blake Waldrop and Corey Clark. This was indisputably a horrific incident. But as the Court of Appeals tells us in Williams v. B. Miller, the court's job is to set aside that sympathy and apply the law to the facts. A neutral application of the law to the facts here reveals that the state does not have jurisdiction.
What's your argument against jurisdictional discovery?
Well, it's several fold.
It seems as though that they've started and so they've alleged sufficient facts in their complaint to give them opportunity to ask your clients a few more questions.
Well, an important nuance that's gotten lost in the shuffle, I think, is that the claim against Clark and Waldrop is for negligent entrustment. In other words, that they were placed on notice of dangerous propensities that Gendron had and proceeded with the sale nonetheless. The plaintiffs do not assert a negligent marketing claim against Waldrop and Clark. That claim is asserted only against RMA.
But they're going to testify anyway in that deposition, aren't they?
Oh, undoubtedly they will, yes.
It's not noticed yet, right? You don't have those scheduled yet?
It may have been noticed, but I don't, it has not been scheduled, no.
What do you think the judge Judge Farrelletto meant at the end when she takes note that these two individuals are going to be deposed anyways. Like, what's the point of that? Status, do you think she was driving at? Was it, well, if you uncover something there that's relevant to jurisdiction, then you can come back and make another application. It's without prejudice. What was the purpose of that?
I read that, I think as Mr. Connors did, as more of an admonition that notwithstanding that these defendants are being dismissed from the case on personal jurisdiction grounds, there's an expectation that they will participate in the discovery process in their capacity as representatives of RMA.
So what's the harm? They got to come here and be deposed anyways. Their business, at least the CEO's business, is still a defendant. What's the harm in holding off on the jurisdictional issue till we hear from them and we can find out what exactly their roles were here? Or do we just take their word for it in their affidavits? Like, what's the harm in just waiting a little bit until you get the deposition, until Mr. Connors gets them in a deposition?
Well, the harm is that number one, it's a pure fishing expedition. And we generally don't let parties do that without some sort of showing. And I submit there is not that showing here, particularly when you view the jurisdictional issue through the lens of the negligent entrustment claim. Because all these allegations about negligent marketing, negligent sale, really do not inform the jurisdictional analysis as to Waldrop and Clark.
Whether one issue on the, I think it's the A3, is whether they derive substantial income.
Yep.
They say, well, we get any income personally. We're just going to take their word for it. Like, can't Mr. Connors cross-examine, maybe subpoena some records? I mean, we're just going to, what kind of legal system is that if we just don't allow anyone to look under the hood with respect to important assertions of fact?
Well, number one, there's no allegation in the complaint that they do have substantial revenue from interstate commerce. Certainly no allegation that's supported by any specific facts.
Right, but this is a 3211 motion, so isn't the standard any cognizable cause of action? And even if he didn't properly allege it, isn't it whether he can formulate a complaint, not whether he did or not?
I don't think so, because the long arm statute analysis under CPLR 302 requires you to look at the New York directed contact of the individual arising out of which the cause of action arises. And here, the only cause of action alleged against Waldrop and Clark is one of negligent entrustment. So that the jurisdictional analysis is confined to the specific facts out of which that cause of action arises, not out of general facts as to RMA's other marketing and sales practices. And so again, I think it's critical that the cause of action alleged against Waldrop and Clark is negligent entrustment, not more generally negligent marketing, because I think that very sharply circumscribes the operative analysis. Now, turning to the Croyder case, every single case that has applied Croyder to find jurisdiction has required that there be highly specific allegations of personal participation by the corporate employee in the facts giving rise to the cause of action asserted against him or her before the acts of the corporation can be imputed to him or her for jurisdictional purposes. And all the cases that have addressed the issue have specifically held that you cannot premise jurisdiction over a corporate actor, over a corporate employee, a corporate principal, based solely on that individual defendant's position in the company or on general allegations that they control the entity.
Well, I think the allegations here, the CEO was directly involved in marketing. Like coming up with that one slogan, like the Villanius, do you want to look like a villain? I forget the exact words of it, but the allegation was he was directly involved in that and some other marketing techniques that is a little different than just a CEO who delegates everything.
Well, no, but that allegation is conclusory and involves conjecture and is not brought home by a specific factual allegation.
That's why they want to question him, right? I mean, they want to put him under oath. Who came up with this? But in any event, what do you make of they seem to rely on that people of state of New York versus Frisco Marketing of New York LLC case? What's your reading of that and how does that not support them?
It doesn't support them because in that case, there were very specific allegations, unlike here, of the individual's involvement in and control over the New York directed activity. In Frisco Marketing, the corporate, I can't remember whether they were officers or directors, but the corporate actors signed the leases for the New York premises out of which the fraudulent sales occurred, were alleged to have engaged in those fraudulent practices themselves. So there were some very specific allegations there of the individual's direct personal participation in the allegedly unlawful conduct.
Are there any cases that you want to bring our attention to that I know you cited quite a few in your case? You want to highlight one here before you sit down?
Oh, I think one would be the Caribou case, which I think catalogs quite extensively the distinctions we're talking about here, the distinction between personal participation on the one hand and allegations of jurisdiction based solely on a corporate position or general allegations of control. And in that regard, the only truly factual, as distinguished from conclusory or conjectural allegations of Mr. Waldrop's involvement come from paragraph 93 of the complaint, where it's alleged that he's chief executive officer and majority owner of RMA. He's intimately involved in the day-to-day operation and management of RMA. He takes part in the design of RMA's body armor. And as Your Honor indicated earlier, personally test the body armor RMA makes on an indoor shooting range. This isn't a products liability case. There's no product defect allegation here. So how, the design and testing of the body armor enters into the jurisdictional analysis escapes me. And then it goes on to say, upon information and belief, Waldrop is directly involved in RMA's marketing and sales and takes an active role in RMA's making and marketing and sales. That's it. That's a boilerplate allegation that can be made about any CEO. And if the court is inclined to find jurisdiction based solely on that, and a factual allegation like that, there's no limit to who it is that can be brought within the jurisdiction of the court.
Do you think it's theoretically possible Waldrop could be in and Clark out or vice versa? They don't necessarily rise or fall together, depending on the facts.
I do agree with that. I think both of them, there's problems with plaintiff's jurisdictional theory as to each of them, but for different reasons. And I'd be happy to go into that. Because I think the case law does require that you look at them as individuals and not simply lump them together. So as to Waldrop, and I just read you really the only factual allegations against him in the complaint. There is absolutely nothing that alleges, suggests, or otherwise indicates that he had anything whatsoever to do with any negligent entrustment of which Clark was aware. There's nothing alleged showing he exercised control over RMA with respect to that claim. Nothing alleged that he exercised any control over Clark with respect to that
Was there
claim.
allegations, we're not getting into whether true or not, but Waldorf knew what Clark was doing. Clark's going on these Reddit sites and various other sites and drumming up business from people that they say are predominated by white supremacists and people who might engage in violent activity by wearing one of these vests. And he knew Clark was doing that and encouraged him to do that. Just an allegation, but that's not relevant here.
Not absent any allegation that Mr. Waldrop was personally involved in any of that.
Okay.
No, again, otherwise you're going to extend the both liability and jurisdiction to virtually every CEO over the acts of any employee, regardless of.
I think it still comes down to whether or not they're a primary actor.
That's right. And the primary actor is a term that seems to have been developed to kind of shorthand the Kreuter test. And the Kreuter test does have a number of specific elements, which includes, as really the entire jurisdictional analysis, both under the long arm statute and under the Constitution, which includes the requirement of a specific direction of activity towards the state. Purposeful, exactly. Purposeful availment of the privilege of conducting activities within the state. And there's no allegation in that regard as to Waldrop. As to Clark, I'll start switching over to Clark now. As Justice Lindley pointed out, Clark had no idea where Gendron was. All of these communications on the Reddit site were purely anonymous. There was no suggestion at all of where Gendron was located. His username didn't suggest any of that. And because the law requires purposeful availment of the privilege of doing business in the jurisdiction, obviously a single anonymous contact doesn't cut it either under the long arm statute or constitutionally. And in addition, with respect to Clark in particular, but also Mr. Waldrop, the plaintiffs have wholly failed to make any showing of interstate revenue or New York revenue so as to satisfy 302A3 of the long arm statute. Now, there's also.
Couldn't that come out from a judicial discovery situation? Well, how much activity do you do in New York State? How much activity do you do interstate throughout the country, except for Connecticut, obviously? That's the only state that it was prohibited internet sale.
Which are legitimate questions of RMA, but Waldrop and Clark have flatly denied that.
Well, you don't know what Mr. Clark's payroll situation was, or you make so many sales, you get a bonus, whatever it might be. Mr. Gendron recommended Clark to have Corey, to get a bonus. They wanted permission to be able to market or promote RMA activity under his rants or his posts, whether or not on Reddit, 4chan, or Parkland, wherever they may have been.
Well, as to the bonus, I think that's.
Well, I don't know. We don't know that. That's probably a valid question.
Yeah, but Mr. Clark is flatly and outright denied in his affidavit any interstate or New York revenue. No ifs, ands, or buts.
Right. Well, that's, I guess, again, beating a dead horse, but I think Mr. Connors might want to question him about his affidavit and the veracity of those allegations. So we have to take a look at whether some pre-action discovery, some jurisdictional discovery would be in order there. But we understand your argument. We appreciate them today. We'll take a close look at the briefs from all sides.
Okay, thanks. If I could just sharpen the pencil very quickly on one point that it is, because it developed primarily on the in the plaintiff's reply, I would like to address it, is that the long arm statute does allow for the establishment of personal jurisdiction over an individual by virtue of the conduct of an agent, and we've talked about that at length, and it's been brief. It's a different situation under the Constitution, though. So the plaintiffs here need to satisfy both the long arm statute and the Constitution in order to get jurisdiction over either Waldrop or Clark. But the Constitution does not allow an agency theory. Where we get that from is from the Supreme Court's decision in Calder versus, which is cited in the parties' briefs. And what the Supreme Court said in Calder is that while employees are not insulated from jurisdiction just because they were working for a company, which is basically the fiduciary shield doctrine, which Kreuter refused to recognize. The Supreme Court also said, by the same token, corporate employees are not subjected to jurisdiction solely because of the actions of their corporation. And that's something that some federal courts, and I'd be happy to cite post-argument authority if the court would find it helpful, but again, because this sort of all just evolved in the plaintiff's reply. But there's courts that refer to this as the no imputed contacts doctrine. So in other words, on the one hand, there's the fiduciary shield doctrine. On the other hand, there's the no imputed contacts doctrine. So under the Constitution, in determining whether or not the minimum contacts required to bring Waldrop and Clark within the court's jurisdiction from a constitutional perspective requires an analysis of their individualized contacts without regard to any RMA corporate contacts. And if you focus solely on Waldrop's and Clark's individual contacts, their awareness of any New York impacts of what they were doing, their embracing of New York's privileges and immunities and protections, and they're reaching into the state, which the Constitution requires from a minimum contacts perspective, that simply is not there under any scenario by virtue of the allegations of the complaint or otherwise.
Thank you very much.
Thank you.
Next case on the calendar is 359 Claude Mayo Construction Company versus Barclay Damon LLP.
57.
Sorry, 50, what did I say?
59.
Oh, I'm sorry, 57. Thank you. The appellant has submitted. We have Mr. Brady here for the respondent. Prevail below. I assume you are asking us to affirm, and you may be heard with respect to that. You're also, nobody would violently object if you wanted to rest on your brief. We'll leave that to you.
Sir, certainly, Your Honor. I'll be very brief. I apologize. I was unaware that the appellant had submitted. The only thing I would cover with Your Honors this morning is that as I was listening to Mr. Connors just now, and as he was kind of explaining the process of setting forth factual allegations and a complaint and the standard on a 3211 motion, which he was facing in his case, it occurred to me that kind of the whole concept of civil practice involves this idea that when a plaintiff's attorney is drafting a complaint, they put forward the best possible version of their client's case. They set forth factual allegations which may bear out in discovery. Some of them may not. But the idea is that they put forward the best possible case. And here in plaintiff's complaint, a plaintiff alleges that Barclay Damon, in bringing a lawsuit against the government, which Barclay Damon advised the plaintiff in writing not to bring, that when Barclay Damon brought that lawsuit against the government in the complaint, it included claims that essentially did not bear out in discovery. That
So you saying that the retainer letter, these letters were documentary proof under 3211A2 that conclusively established no merit to the claim? Or are you going more on 3211A7?
3211A1, Your Honor, that
I'm sorry, yeah,
yes,
A1, yes, I'm sorry.
yes, that not only was the plaintiff explicitly advised before bringing the lawsuit in writing that the plaintiff should not go forward with the lawsuit because of the uncertainty of a favorable outcome and because of the expense, but also the crux of plaintiff's complaint against Barclay Damon here is that by including claims in its complaint below in the lawsuit that Barclay Damon told it not to bring, that it ultimately did not recover on, that Barclay Damon had committed malpractice, is just not in concert with the law, and that an attorney is not held to a infallibility, is not held to a level of being able to predict all of the possible weaknesses in the plaintiff's case, and that as we set forth in our brief, the fact of the settlements and the fact of the explicit forewarning prior to bringing the lawsuit sever any but-for causation in plaintiff's legal malpractice claim. And with that, Your Honor, I'll submit unless the court has any questions.
Thank you.
Thank you.
Case 348. Alam Taser versus Roswell Cancer Institute Corporation, 358. Did I get that one brought there?
348.
Oh my goodness, this is I think I got my wing out here. 358, I'm sorry, 358. Counselor, good morning to you.
Good morning, Your Honors. May it please the court. I would like to first of all draw your attention to the scope of this litigation. This case was brought for very limited purposes. It was brought relative to the defendant's admissions that they misdiagnosed Mr. Almentasser with cancer, which caused him to then have to undergo radiation surgery, then followed by surgery, and under which he contracted MRSA that caused him to have significant amounts of treatment, hospitalizations thereafter. Importantly, though, as is indicated in our papers, there's a finite amount of damages in this case. This is not a case where we're claiming that something was.
Talking about 6 months or 9 months. Or
it was
less than a year, I think it was.
And I know where you're getting that from. That relates.
We don't know really where I'm really going to get is.
No, maybe we're
we understand the limit on, but how far is a court supposed to go to give somebody leeway? I mean, here there was years of non-compliance, and still to this day, one of them, the plaintiff has not testified in the EBT, correct? Nora has not testified.
She has not testified. The schedule was such that the defendants were, the schedule was such that we were to depose the defendants first. It was a little bit out of order, and then they were going to depose Nora. And
now the deceased testified, though.
The deceased had already testified pursuant to a court order that ordered us to produce the claimant in the singular for a 58 hearing. And that did take place. And in his testimony, he clearly defined what the injuries were, in fact, and they were limited by the period of time which he lived. He lived only a short period of time until 2017, and then he passed away, and all damages ceased as of that time because we were not making claims for wrongful death. So, and I understand that the court would be concerned about the way that this went down. And certainly it's our position that this court has already evaluated all of the efforts that were made by the plaintiff prior to its decision in 2020. That's already been evaluated. That should not factor into, in our position, should not be factoring into what happened at the time that this case was dismissed.
Don't we have a non-compliance with our previous order?
Well, relative to the supplemental bill particulars.
Right.
And that could be an issue, but by the time the judge had, in fact, rendered his decision to dismiss, we had provided a supplemental bill of particulars, and that is in the record. But the fact of the matter is, at no time, and you'll see this in the record, was there any reference after we were at the appellate division to there being an order that the plaintiff and should supplement their bill of particulars. They were the defendants seemed to be most interested in getting the 25 authorizations that we gave right away. And I think that one of the most important things to take into consideration is at the time that the motion was argued, and certainly by the time that they brought the motion, they had been provided with every single authorization or a record that they were requesting. And it's very evident when you're reading their brief, there isn't a single thing that they can rely upon to say that they were missing. They were not missing a single thing, and they never raised the issue of the supplemental bill of particulars. And I think more importantly, this is not a situation where we were failing to prosecute. There was numerous efforts made by our office, in particular by my husband, Phil, over the period of time since the appellate division rendered its decision to try and get all of the records that they were demanding, and they kept demanding more records, and it was a never-ending situation. But the court was intimately involved in all of the efforts that we had to make to provide a subpoena. But concurrent with the court's interest in making sure that litigation moves forward in a timely manner, it is my position that you also have to consider what the law dictates. And the law was not followed in this case. Specifically, and this court's multiple decisions have repeatedly held that a court may not even do an end run around against, or strike that, I'm sorry, cannot even reach the merits of a motion under 3126 for failure to dismiss, for failure to prosecute, unless the conditions precedent of 3216 have been strictly complied with. And in this case, they were not. The court can't do an end run around the demands of 3216 that requires, in order to grant dismissal, there has to have been a 90-day notice either by the court or the defendant, and that never happened in this case. So it's our position that service of the 90-day notice was never given, and this court, even in the Hillier case, as we've cited in our brief, has overlooked the failure to comply with numerous scheduling orders in that case, and a 90-day demand that had been served by the defendant, and there was no good cause shown in that case for the failure to provide a note of issue. And this court held that the merits of that case should not even have been considered, even in light of the fact that there was no good cause or reasonable excuse provided.
Right, and your brief goes through this in great detail. I think what your general tenor of your points is that we, like all courts, have a strong preference to resolve cases on the merits.
Right.
And it seems on the surface, there's a very valid claim here with respect to the husband. They took out a mass they thought was cancer. It turned out not to be. And then allegedly, and it was just allegations, that led to an infection and his death. And you feel that you acknowledge there's been some discovery issues, let's put it mildly, and
Yeah.
extenuating circumstances, various people in your firm, but all in all, if we were to affirm this, this man's family, he's deceased now, they won't have their day in court. And that maybe there's some other sanctions that might be appropriate, but dismissal is too drastic.
And I think Your Honor is well aware, because you sat on the case of Volosic recently, where we had the very same situation. Certainly, there were no discovery violations on our part or lapses. But in that case, where the defendants were outrightly lying to the court, found to be outrightly lying to the court about documents that they maintained in their own document retention system, and lying for years, telling us that those didn't exist. Wasn't until I found them in another attorney's file that it came to light that they had been lying. Even in that situation, this court reversed the striking of the answer. And to put our clients through a situation where they will not get their day in court would be hugely unfair in light of what this court has done in other similar cases, and particularly given the fact that the defendant has shown zero prejudice. Zero prejudice has been shown by them. And that was something that was relied upon heavily by this court when coming to its decision in the Lolosa case the first time it was up, even though there actually was prejudice because we still didn't have the documents. In this case, the subpoena documents, even the ones from Michigan, were all in their hands prior to the time that they made their motions. Some of which, by the way, even though they still moved on them, in May of 2022, they had those documents in October of 2021.
At least say the prejudice is that memories have faded. We're going back over a decade and people might not be employed there. But is there some lesser sanction that you think might be appropriate here? Not that, you're in the business of trying to say what your sanction should be, but you would like no sanction, but is there something in between nothing and outright dismissal that we could consider?
Well, I certainly hope that you would. And I guess I'm not really in a position to suggest what would be. I think that there's a very big difference in this case, given the exigencies of not only the people in my firm, but also my personal family situation. And it's not a pretty situation in life in general. So it's just, it is what it is. And we've tried to move forward, but certainly Judge Sampson didn't even consider the doctor's declarations that had been submitted to him to explain that we did have good cause. And he took the position that he couldn't consider any of that because Phil didn't call him before the date that the thing, scheduling order expired. The reality of it is when you're in kidney failure or liver failure rather, and having all sorts of mental issues as well, the last thing on your mind is to be, calling a court. And on top of it, the person who was responsible in our office and who had handled all these issues and would have probably reminded me was out with her own issues. So it just,
it was a litany of woes that I have not seen before in a single law firm.
Unfortunately, it's the story of our lives, but it is true and it's no joke. And we have endeavored throughout our careers, and as most of the judges who are here on this panel who have encountered us will tell you that this is not the norm for us. It's not the way we like to practice law, but there's a myriad of issues, including people leaving our firm and stealing from us basically, which we have litigation over that too. So it's our position that we are not contumacious. We're not willfully trying to refuse to comply. We've made many efforts to try and get together with the court, the defendants. The ball kept moving as to what we were, what the objective really was, which was probably all along to get us in a situation where the case could be dismissed. So it's our position that certainly that this court has considered the issue, Judge, that you raised about memories being diminished in the Boeing case, held that in particular in a medical malpractice case, the hospital records and the doctor's reports, which are solely contained within the defendant's control. I mean, this record is limited to Roswell Park's records, their own records, that those records serve to restore diminished memories of hospital staff and aid in its ability to investigate and to defend claims such as this. So it's our position that, and I appreciate the court's indulgence and listening to the issues that we have faced, and I appreciate the fact that maybe you believe that there should be some sanctions awarded. I'm just not sure what that would be. But,
Thank you for your time.
thank you.
Yep.
May it please the court, Amanda Rossi on behalf of Roswell Park. I disagree with some of the recitation of the procedural history by the claimant, but quite frankly, the court does not need my rhetoric on this because it's right in the record. The record before the court is long, but it is not complicated. And that's what Judge Sampson did in this case. He read the record and he spent 12 pages discussing the many instances where the claimant ignored good faith requests, delayed discovery for no reason, disregarded court directives at pretrial conferences, and violated 5 different court orders, including one from this court. And frankly, he didn't get all of it, but he certainly hit the most salient points. Now, there's no question that the motion was made pursuant to 3126. That was what the motion was filed under. The court cited that provision, and he cited case law discussing that provision. So what we have here is the standard of review being an abuse of discretion. And certainly, Judge Sampson had ample factual basis to decide to issue an order that dismissed this case for the claimant's refusal to obey court orders, willful and contumaciously refusing to comply with the law, with orders for 10 years. And he also had ample legal basis to do this. He cited cases from this court and the Court of Appeals. The Court of Appeals said on this point that a litigant cannot ignore court orders with impunity because it threatens the very integrity of our judicial system. And this is not me standing on a soapbox. This is what Judge Kaye said in the Kyle versus Pfeiffer case. And there have been many other cases since then that have stood for the same proposition that this particular provision that the legislature issued permits a court to use its discretion to issue sanctions that it feels are just, depending on what has occurred. Now, in the Andrea case, the Court of Appeals expressed the fact that, although sometimes unfair, a litigant may be held responsible for the actions of its attorneys. And that is, again, binding precedent from the Court of Appeals. I would argue to you that Judge Sampson had no choice but to follow that precedent in this case, where we have now the passage of 13 years and no 50H or deposition of the claimant.
There was one of her husband, right?
Correct. And she was a claimant at that time as well. And we noticed her for a 50H and she was not produced.
So the claim is primarily what happened to the husband. I mean, I know there's a derivative claim. And yes, I'm not excusing the fact, I mean, it's 13 years, long time with not a single deposition. I get that, but yeah, you make a lot of good points. We're going to have to wrestle with this. It's a difficult situation because the party that's affected the most is not counsel, but counsel's client. And that's something we take seriously, depriving somebody of their day for it.
Thank you, Judge. I do appreciate that. And again, I'll just reference the Court of Appeals decision and Andrea on that point. If there are no questions, I will otherwise rest.
Thank you so much.
Thank you.
We have now case 360. Ardalan versus Safai. We have a recuser. Judge Payne is recusing. We have Judge Smith will be stepping in. Oh, there she is. Judge Smith is there. Ready and raring to go.
Jeanette's on this one too. I thought Jeanette's was going off this one.
Yes, Jeanette, I believe you have recused on this one as well, just as I did.
Yes, that is correct. Yes, I'm sorry. I will step out.
Okay. Thank you so much. All right, counselors, as you can see, we had 2 recusals. We have a substitution of Judge Smith. We need 4 for a bench, and we have 4 now, so you may proceed with the argument. Thank you for your patience.
Thank you. May it please the court, Joshua Glasgow for Cyrus Ardalan. The record in this case demonstrates that respondent breached her fiduciary duties. At the very least, it presents a triable issue of fact on that question that should have precluded the grant of her motion to dismiss. Now, many of the key facts can be drawn from respondent's own admissions in her affidavits. She admits that the property at issue was owned by herself and Mr. Ardalan. She says that for that reason, one or both of us needed to travel to Iran to complete the transaction. She acknowledges that she went to Iran to complete the transaction. Now, there's no dispute that the power of attorney authorized her to transmit Mr. Ardalan's interest in the property. And there's no dispute that 1/3 of the proceeds, approximately $320,000, was given in the form of an apartment. But respondent concealed that information from Mr. Ardalan. He didn't know that 1/3 of the proceeds, $320,000, were locked up in that apartment. Instead, he was led to believe that only the cash proceeds of the sale were available.
The mother went into the apartment, right? The mother lived there and kept it for a number of years. And
that's correct. There's no dispute also that the apartment was in respondent's name. And she has some sort of contradictory testimony on this point, affidavits on this point. She says, on one hand, she wasn't clear on what the details of the transaction were. She didn't really know about the apartment being 1/3 of the proceeds. On the other hand, she also says the apartment was placed in my name, and she claims that the money from the apartment was intended to go to her son at some point. So these
rented out to, there was some leasing. Am I correct that the value of that apartment decreased over time?
That's right. And at the time in 2004, and this is in the documents, it's $320,000. It's accepted in lieu of $320,000. Eventually, 15 years later, the apartment is sold in 2019 for, I believe it's something like $52,000. My client got half of that, $26,000. And so, the analogy I draw here is, imagine if a trustee sells a beneficiary's property, takes 1/3 of it and purchases a car, lets a third party use that car for 15 years, and then sells the car for 15% of its original value.
Right. And the difference with your analogy is that the value of cars almost always depreciate unless it's a collector's item. Real estate usually increases in value, and that did not happen here, unfortunately.
Yeah, there's some evidence in the record that the Iranian economy had suffered due to various sanctions, and so this wasn't it wasn't unique to this apartment, certainly. But the failure to disclose here is clearly a breach of fiduciary duty. Whether this was supposed to be an investment, I don't think there's really any argument that this was supposed to be an investment for the benefit of Mr. Ardalan. Respondent says the apartment was going to be sold eventually, and the proceeds were to be given to my son. There's no authority whatsoever for that sort of transaction to occur. I drew the analogy to a trustee, but I'd ask the court too to imagine any other context in which a fiduciary relationship exists. Would the various excuses that respondents offered fly? And I'll turn to those in turn, and I hope to explain them in greater detail. But think of an attorney who settles a case on behalf of a client. There's no way that the attorney could say, well, I gave 1/3 of the settlement amount to the client's mother. I didn't tell the client about that, but the mother was really in charge of the case. I didn't know the details of the settlement. Everything's fine. That's not an appropriate exercise of discretion by a fiduciary. So I'd like to talk about the different sort of reasons that respondent offers. The first is she claims that Mr. Arlen himself agreed to this transaction, and she claims that he signed a deed of conveyance in 2003. And this is the argument that I think most clearly runs into the problem of the procedure in this case. This is on a motion to dismiss. Mr. Arlen squarely denies that he signed that document. He has a statement, sworn statement. I did not see the deed of conveyance until these proceedings. I did not sign it. He goes even further, and you can look at this. It's at the record at page 307 to 309. He points to instances where his signature is in the record, and it doesn't bear any resemblance to the signature that's on this deed of conveyance. The court can't simply believe that this signature is valid given this sworn statement that he didn't sign the document. It would be wholly inappropriate to grant a motion to dismiss on this basis. A second argument is that maybe the power of attorney wasn't used in this transaction. And again, you can look at the respondent's own statement. She says, because we owned the property, one of us needed to go to Iran. She went to Iran and the property gets sold. You can certainly infer from those facts that she used the power of attorney. How else did she transfer the admitted interest that she and Mr. Arlen had in the property? I'd also point out that we don't know the exact details of what happened in Iran. We haven't had the opportunity to cross-examine respondent, obviously, given that this was a motion to dismiss. But any ambiguity on that score should counsel against the grant of a motion to dismiss, not in favor of a motion to dismiss. The third argument is that essentially the mother was in charge of this transaction. Respondent claims I didn't know the exact details. My mother handled it. Even if that were true, that doesn't excuse the fiduciary duty breach. Fiduciary has a duty of vigilance. She can't simply say someone else handled it. I didn't monitor them. I don't know what happened. That's not an
Was your accounting claim or cause of action also dismissed?
The accounting claim was also dismissed. Her claim is that I produced all relevant documents. Certainly we dispute that. But again, even if that were true, an accounting can also be used as a measure of damages. So I think the accounting and the breach of fiduciary duty claim really go hand in hand here. The third argument, and I sort of touched on this at the beginning, is that there were no damages. Again, we have a difference between $320,000 and $50,000. The fact that he got some proceeds 15 years later is simply not sufficient to excuse the failure to disclose this transaction and the failure to account for it at the time. I think it's telling that the bulk of respondent's brief is about alternative arguments. These are arguments that the trial court didn't reach, and I don't think the court really needs to reach them here. But there's an argument that the power of attorney wasn't valid. I think certainly there's no conclusive showing of invalidity on respondent's part. There was an argument about real property law, section 301, which requires a certificate of compliance with foreign law. That statute doesn't apply because it only covers property sold in this state. This property was in Iran, not here. There was also some reliance on a prior version of general obligations law. That version went into effect in 1999. The power of attorney here was signed in 1996, so it wouldn't apply. I'd also note that the current version of that statute applies to powers of attorneys executed in New York, and this power of attorney was executed in Washington, D.C. Mr. Arlen's claims are timely for two independent reasons. First, there's a 6-year limitations period for breach of fiduciary duty claims that starts when the fiduciary relationship ends. So here, it's undisputed there's a payment to Mr. Arlen in 2019 of the proceeds from the apartment, $26,000. That's the final payment. So that's the date, even under her theory, that the fiduciary relationship ends. The case is filed about 1.5 years later. There's also the discovery rule for fraud. We discovered the apartment transaction after this case was filed. And so obviously the 2-year limitations period under discovery rule would not have run. And then finally, I'd point out that the argument that this case should be tried in Iran is really a non-starter. It's undisputed. Respondent admits that Mr. Arlen can't travel to Iran. We have 2 New York residents here. The claims are based on New York law. There's simply no real reason to transfer them.
Probably fears you might not get the most fair trial and you might not actually get home.
That's right. That's right. I certainly wouldn't be ashamed. So, if the court has any questions, I think, the key point here is the procedural aspect. We talked about this as a 3211 motion. Technically, it's a CPLR 404 motion because this was a special proceeding, but it's the same standard. Under CPLR 409, summary disposition is acceptable only if there are no triable issues of fact. At the very least, there are triable issues of fact here.
Okay, thank you for your argument.
Thank you.
Good afternoon, Your Honors. May it please the court, Jeffrey Novak on behalf of the respondents. I know we've been here for a while this morning, so I'm certainly not going to attempt to simply repackage my papers. But a lot like Mr. Brady from a case or two before, I kind of picked up something from Mr. Connors as well this morning. And it's one of those cases where, especially a case like this, where you're reading your papers over the night before, the morning of, it's a kaleidoscope. Different things jump out at you at different times. So I just wanted to hit a couple of key points, and maybe that I didn't emphasize enough in my papers on a second look. The first issue, as counsel for the petitioner pointed out, is this was brought as a special proceeding. This was brought as a special proceeding. That was their choice to do that. They brought it by verified petition. And if you look at their papers as well, in response to our motion to dismiss, they were certainly more than happy to ask the court at that time. They were asking the court at that time to make a summary award to the petitioner of $160,000. So I've been accused of using old folksy saying sometimes what's good for the goose is good for the gander on this one.
That certainly qualifies an old folksy saying.
Right. Maybe I'm, beyond my years in that regard, but I think I wanted to address that issue first, because it was raised here this afternoon, is that I don't know that there's any impropriety in terms of what the trial court found on a motion to dismiss, because again, also on a motion to dismiss, when you have documentary evidence and you have affidavits that might be competing, but the court found at the trial court level that portions of the petitioner's affidavit were disputed by documentary evidence and certainly just weren't believable. And I think that that's supported by, if you look at the history of this case, and it's all in the records, the underlying petition, the first petition, the pre-suit litigation letters from his attorneys, his story evolves and changes over time. And initially it goes from, you sold this piece of property and I got nothing, and you owe me, at one point it was $1 million, one point it was 1.5, I think it went back down to $1 million. The story was always changing, always evolving. So I think the issue there is that also was put under a spotlight on the motion to dismiss, because there's certain elements of his affidavit that simply aren't believable. And one of the items that jumped out, again, a lot like Mr. Connors this morning, reviewing my papers, is we have before the court, part of the record, one of our arguments on the discovery accrual rule was that there was no fraud here, there was no active concealment, and they've produced no documentation, no emails, no texts, no letters, anything like that to show.
Any issue your client used the power of attorney to complete these transactions?
Well, the power of attorney, I would point out a few things, Judge. First off, if you wanted to make the assumption, or if you were to make the finding that the power of attorney was used and that the power of attorney was valid under New York law, it's also a general power of attorney. And the language in the general power of attorney provided my client the right to delegate and also the right to, and I'll quote the language, may conduct the sale of grantor's property at a price deemed appropriate.
So they did use it. They did use it then.
Well, we don't know, Judge. I do not believe that they
How
did.
did the transaction take place then? If there wasn't a power of attorney that was used.
Well, and I think that goes to the issue of whether the court wants to determine it on a jurisdictional issue, or we made the argument of forum nonconvenience. I think that's an issue of Iranian law. I think that's a factual issue of, for lack of a better phrase, how they do things there. I've never practiced in Iran. I've never been there. I don't know how real estate transactions go in that country. And I think that goes to the argument of his believability as well, because we made allegations in our motion to dismiss, we showed that we have this deed of conveyance from 2003. We said he went to New York City. Both parties went to New York City and met with the buyer of the property, Mr. Azim Zadi. That was never denied anywhere in their papers. He's denying that he allegedly signed that document, but he never denied he went to New York City and met with the buyer. So there's this narrative that for some reason, somehow he's sending his sister over to Iran to sell this property on his behalf and doesn't know what it's being sold for.
Sounds like there may be some issues of fact here, though.
He doesn't know the amount.
Dismissed, so.
Well, but the reality is, Judge, that there's no.
Your reality or
There's no damages, Judge. He gets half of everything. He got half of the cash proceeds.
Shouldn't he got half of what the apartment was worth at the time?
That would assume a number of factual and legal issues that I don't know how a court could get to.
That may not be, maybe it'd be too early for 3211.
Judge, for him to, his argument has basically evolved from I got paid nothing, you owe me $1 million, $1.5 million, to okay, I got half the cash proceeds, which allegedly he did not remember at the time until he was shown the checks, to I should have gotten half the cash value of the apartment in 2003, but we have no information.
He apparently had no idea that that was part of the transaction, though.
And neither did my client, Judge. My client did not know.
Maybe your client's entitled to a little more money.
The joke was made that perhaps it was bought in a bad neighborhood, but I mean, that's a question that we're never going to be able to address or get to. The party's mother is dead. She was involved in this transaction. Mr. Azim Zadi, the buyer, he's in Iran. So the people that would have information as to this transaction, what the details of it were, are either dead or unavailable to the parties, certainly unavailable to my client. And it would be prejudicial for her to continue to have to litigate this case in New York with essentially one or both hands tied behind her back. And I did want to point out one item for the court today. Again, something that jumped out at me last night. We put in the record in face of his argument that items were concealed from him, there's a fraud committed, and the discovery accrual rule should apply. We put in the record that part of their original petition, one of their exhibits was actually bore a fax notation at the top dated 2006. And it was our claim that he was asking questions, investigating this transaction in 2006, and that fax transmission was part of his investigation that was conducted. Again, I don't believe there was ever anything in the papers that was ever addressed by the petitioner. What was that document? Why were you collecting it in 2006? But I think it's interesting to note that his claim is that there's an affidavit submitted by him, and there was also an affidavit submitted by his half brother. And this was, unfortunately, the procedural history of this case.
Half brother in Iran or no?
His half brother, I believe, lives in California, if I'm not mistaken. The initial arguments they made in this case, Judge, were that the documents we gave them referred to a different piece of property. That's not the property that you sold. The other property is much bigger. So in support of that, they submitted this affidavit from their half brother. And both in that affidavit and in the petitioner's affidavit, they reference a meeting that occurred amongst the family in 2006. The half brother, and there's more half brothers. There's, I think, 3 of them. There's 3 half brothers. They come to visit in 2006. This is approximately 2.5 years after this property sold. The half brothers way back had an interest in this property, and they signed off on paperwork and they basically surrendered their interest in the property. But in 2006, the half brothers are talking to the party's mother when they come to visit, and they say, you know, that property was sold. Didn't we had an interest in that property, didn't we? Shouldn't we get some money out of that? Now, the half brother and the petitioner both say petitioner excuses himself from that conversation. They both say he excuses himself because it didn't concern him. It was a family issue between his mother, Fatima, and half brothers. How can that not concern him? He's saying he owns.
Thought I was the bigger property.
He's saying, well, he's saying he owns the property. And the half brothers are saying, we have an interest in that property. He's saying he owns it. He just sold it. He just got the money for it. And I think that, again, that goes to what was really going on here amongst the family.
I think we're getting off the track with all these half brothers. So you want to wind up?
Well, the point, Judge, is that at the end of the day, the party's mother was running the show in the family. Whatever was on paper was one thing, but she was running the affairs of the family. And that explains why she was able to basically modify the deal, why she decided what money was going to go to the petitioner, and why she kept the apartment for herself. But then again, at the end of the day, the apartment was sold, he got half of it.
She's dead.
And she's dead. And so again, my client's stuck in a situation where how can she defend this action? And just as to the accounting, my client's gone to great expense to not only go send representatives into Iran that are there, into the local clerk's offices, into the real estate offices that they have there, pull those documents out, get them translated, thousands and thousands of dollars. One, why would she do that if she was committing a fraud on her brother? Why would she go to that expense to basically put everything in front of him and say, there's nothing untoward here?
Yeah.
But the second issue is this accounting claim. The trial court recognized this. We've disclosed every document that we have.
All right, we get that argument, and you made that very well in your briefs. We appreciate your time this morning and your hard work on behalf of your client.
Thank you, Judge.
Thank you very much.